में 3 नंबर ये 1564 चलिए 1 नंबर 2 नंबर कहाँ लगा? 3 नंबर तो दिख नहीं रहा।
हेलो
4 नंबर है।
हेलो
ये 3 नंबर है। सीधा मिलाओ पूरा पहले मिलाओ। चलो 35 नंबर
35 नंबर ठीक है।
2 नंबर 462
462
हाँ 3 नंबर 1564 हाँ 4 नंबर 163 5 नंबर 318 1 26
नंबर हाँ
7 नंबर 70
70
8 नंबर 28 9 नंबर 140 10 नंबर 145
ठीक
हेलो
ये 156 है ना सर?
ऐसे काम हाँ दोनों साइड मिला के काम किया
अरे सॉरी
Yes.
ये सब साफ होना चाहिए।
There is adrenaline rush that keeps you excited. So something you can't sleep. That goes with me at least. Nah, there you will, find me always at the end of the line. There are people, who own fantastically. I'm telling you, the kind of tea I get, the kind of tea young boys are now getting.
ये बात यहाँ से सुना है आवाज नहीं सुनाई दे रहा
बहुत से सुबह सिटिंग की होते हैं, I get a bit of a culture. Morning walk में जब करते हैं 6:30 बजे बैठ जाते हैं, give it a 5 minutes. 6:30 in the morning, but I was sweating AC से चलाने का t-shirt and wet and all. Yes, lovely night now. All desertification that is taking place. क्या डियर क्या कर रहे हो? ये था मेंशनिंग छुट्टी के पहले बड़े अर्नेस्ट हो यार तुम लोग अपने काम में, उनको छुट्टी के बाद रखवाने के लिए आए। बड़े अर्नेस्ट हो आप लोग। Man, end of the after good 34 years, I've come to realize something, that there is nothing known as urgent in legal or treat. It may be urgent for your client, you may come running, stay चाहिए, ये चाहिए, वो चाहिए, all that. बट ऐसा नहीं है कि अगर कोई स्टे नहीं मिला या अगर कोई इंटरिम ऑर्डर नहीं मिला या प्रोटेक्शन नहीं मिला तो उसके साथ कोई अनहोनी होगी, परेशानी पड़ सकती है, लेकिन कोई बहुत उससे फर्क नहीं पड़ता है। अच्छा अनदर थिंग व्हिच आई हैव सीन इज ये केस जो है ना जैसे लीगल होना शुरू होगा, एक समय आएगा जब वो अपने आप ही हिल जुल के सेटल हो जाएगा, बिना कोई फाइनल ऑर्डर पास हुए, बिना कुछ हुए वो हिल जुल के अपने आप ही बस ठीक हो जाएगा, सेटल हो जाएगा। It will meet its own end, so to say. I mean, death I would not say, but end, so to say. So, no harm. So you're working with Kiran Singh as his junior, or you are an assistant? As his junior, not as assistant. But you must be eligible now for assistant. Then why is he not recommending you?
No, he has sent the names, but
What was the fallout of that event that took place thereafter?
again went to his court, but then he said no, it has been disputed by him, and he would have decided not to. And then he informed us.
And did you get the letter from there that ASG would be appearing?
Then Sanjay sir called sir, complained about me, and then asked for the letter.
Asked for?
The letter. And I'm appearing for last 20-25 years for PCI, why we are fighting among the partners.
कोई लोग यहाँ स्कूल में कहते हैं ना, लगाएंगे का साकर है तो ढोल I mean, if you understand.
हाँ हाँ
तो वही है, तो I mean, अगर आप छेप गए तो आप क्या करिएगा, तो यू आर द डेवल ऑफ पीस, आपको गाली देंगे क्या? जा रहा है। मजे की बात ये है कि जैसे जैसे यू गो अप, पढ़ते थे फेलियर वगैरह में, तो वर्ड जो यूज करते थे तो फ्रेज द मोर यू गो अप द शिट स्टिंक्स मोर। So ये लोग अब इतना धीरे 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 जैसे जैसे ऊंचा होते चले जा रहे हैं, 40 years of practice, 30 years of practice, 35 years of practice, उसके बाद भी that's a nice way to shut me up. Shut it off because समाज they came and switched it. No, the wheel is not moving. The wheel of justice is not moving. Call it wheel of justice. And brings all the justice from lower earths to the higher earth.
now it is moving.
So we can say justice is moving. You know, it's an art to see humor in everything.
Yes.
May I have my Lord's leave to mention, my Lords, item number 9, my Lords, LPA number 141 of 21, Akhtar Ali.
Yes.
My Lords, may I pray that this be taken up after vacations, my Lords? It is more
There's
of...
no difficulty. But then such prayer we are expecting to come in every matter today. That's the whole difficulty.
My Lords, here...
There's no problem. I have so many cases on my list. If one case is heard after, nothing is going to happen. It's you who is interested in this appeal. But the difficulty with the bench is this. Unless all of you decide that no, the bench is not required today, we'll merrily go off.
No, my Lord, I can't speak for my friends, but...
I think all the councils that I see, their cases are listed in priority.
Yes, yes.
Very well.
My Lord,
have you informed the other side?
My Lord, I'll do so.
No,
But
please inform the other side.
I'll do that.
Let your junior come and say that the other side has been informed. We'll make an adjournment.
Very well.
Remind somebody should be here to remind
This
us.
is now more in the academic side, my Lord. I mean, the discussion would be
That's
more
right,
of
but then
academic
the other
nature,
side
my
has to be
Lords.
informed, no? The other side has to be informed.
Very well, my Lord. I'll do that.
Inform, and somebody should be here to remind the
Very
court.
well. Very well.
All right. So after vacation you want?
Yes.
You please go and inform.
I'll do that.
Like
I'll do that. My Lord will take my word for it.
As prayed for on behalf of the appellant, re-notify this case on to give in the 27th of June.
Very well. So obliged.
Mr. Sanjay Singh, Lund, senior advocate, has told this court, has assured this court that the counsel for the other side shall also be informed of this adjournment today. All right.
I shall do it.
Lord-
Obliged. Obliged.
Yes.
Lord, in item number 5, I am praying for only, may Lordship may kindly fix this case for 1 p.m. because the...
Pray for?
1 p.m. 1 p.m. Lordship, because the arguing counsel is busy in court number 2. So it's a matter, Lordship, in which the counsel from outside is also present. So only for 1 p.m. Lordship, the other side is present here.
We don't do it today.
अगर जितनी जल्दी फ्री हो जाएंगे तो हम आ जाएंगे, but on safer side, Lordship.
No. To be on the safer side, we pass it over. Come back tomorrow as the first case.
जी ठीक है तो ठीक है
इसको pass over कर दीजिए.
जी thank
Item number 5 with जितना है all passed over. Tomorrow. Yes.
I may be permitted to mention, Your Lordship, This is LPA number 88 of 2022, Your Lordship.
Number, serial number?
It is not in the list, Your Lordship, out of the list, Your Lordship.
Yes.
I'm mentioning this case, Your Lordship, because it is related to the appointment of the for the post of librarian. Now, Your Lordship, this matter
Librarian where?
in Zilla Parishad, Your Lordship. Now, this matter is not listed in any of the consolidated lists. So, on last week, I mentioned before the registrar list and computer, and this week the consolidated list of Your Lordship has not been printed. So, Your Lordship, I'm mentioning it here before Your Lordship because there are only 2 benches for the LPA. One is DB2, Your Lordship, and in this case, the order which is in challenge, the order has been passed by Honorable Mr. Justice Mohit Shah. So, obviously, it will not go before that DB, Your Lordship.
That's right, but the difficulty, as Prakrita, is this. Without the assignment of the case, can I direct for its listing? That's the whole problem. You're right. Ultimately, if it goes to DB2, it has to come here.
Your Lordship.
Or some special bench has to be constituted. So this or a special bench has to be constituted, of which Justice Mohit Shah would not be a member. So this decision lies with the Chief Justice.
Your Lordship, I totally agree, Your Lordship, but because of this difficulty,
Therefore,
only last week I didn't
know,
mention before,
I
Your Lordship.
I can understand that. So what you do is this. I mean, we can only suggest you that you make a mention before the Chief Justice today. Right.
It is stand over, Your Lordship.
Stand over. So tomorrow make a mention there, and if he says that he can, you can mention it here, we'll have it listed. If not, then you mention sometimes if there is any urgency, you mention during the vacation, if it is urgent. If it is not urgent, please wait for the courts to reopen after summer vacation. Because we can't, unless it is assigned, we can't direct it to be listed. That's our problem.
Your Lordship, urgency is very subjective. It totally depends upon our understanding.
Assessment.
It might be possible that Your Lordship didn't find it urgent and my client find it urgent.
You're being absolutely clear in your approach. We appreciate that. But then without assignment, we find it difficult to list it.
So may I have the liberty to mention it tomorrow over here, Your Lordship?
No, only after you have mentioned before the Chief Justice.
Your Lordship.
And you tell the Chief Justice that there are only 2 benches available. One would normally be scored out for the reason that it comprises a judge whose order has been under challenge. Therefore, the only other bench would be this. So, if permitted, you can mention. Then only I can take. See, otherwise, I'll be exceeding my jurisdiction. I am only DB5. Huh? I don't have the powers of DB1.
Obliged, Your Lordship.
Yes.
May I pray, my lord, with regard to item number 10?
10.
Yes, LPA 147 of 2021. In this case, arguing counsel Mr. Narayan Singh is bedridden right now because he has a heat stroke.
This court has been informed that Mr. Narayan Singh, Mr. Narayan Singh, learned senior advocate who is to address this court, has suffered heat stroke. As such, the prayer for adjournment is allowed. Let the matter be listed for consideration on 28th of June.
Obliged, my lord.
Caller.
And here to mention Silvan, Mr. Abdul Wadud.
You are withdrawing it? You are Mr. Abdul Wadud?
I am Abdul Wadud.
You are Abdul Wadud?
Yes, my lord.
Mr. Abdul Wadud, learned advocate for the petitioner, seeks permission to withdraw this petition. Dismissed is withdrawn.
For order to Mr. Nirmal Kumar.
ये भी withdraw करना है?
Yes, fine.
Very good. Mr. Nirmal Kumar, learned counsel for the appellant, seeks permission to withdraw this appeal. Dismissed is withdrawn.
Obliged.
Series 3, Mr. Ranjit Kumar Yadav.
Yes.
My lord, on earlier occasion direction was
On the mic. There is some problem with the mic. Unless you speak just in front of the mic, you will not be heard.
sorry. Okay.
Yes.
My lord, on last occasion, my lord has directed to issue notice and also directed the Bihar School Exemption
Has the
Board.
notice been served?
And a notice requisition was submitted and probably it may be served, my lord.
Just let us see. We have issued notice to respond number 5.
My lord.
Who is this respond number 5? The Principal Secretary, Primary Teachers Training College. Service report has already not been received. And counter affidavit had to be filed by Mr. Gyan. Where is he?
Your Lordship, he is in court number 14.
But he must have given you some instruction.
So he asked me to take time for filing the counter affidavit. We have received the file just up last week.
You should have come in the beginning. Before Mr. Yadav, you should have come and said that you appear for respondent numbers 1 to 4. Since the lawyer is not here, you are taking the leave to seek adjournment. Now, by what time would you file counter affidavit?
So 2 weeks.
2 weeks, the courts will not be available for you.
So after vacation.
Why this? Is it not deliberate that you are asking this case to be postponed unnecessarily? The matter is urgent. Some friend of his has been allowed to appear in the examination. His certificate has been issued. He has been left behind and he loses his job because of this. So whether he loses his job or he doesn't, that's something else. That shall be decided on merits. But why delay at our end?
I'm sorry, Your Lordship.
That is the urgency. Urgency is not a particular case. Urgency is the issue.
I understand.
There
Your
are
Lordship.
hundreds of cases. One gets passed over, doesn't matter. The second one will come in queue. But these are urgent matters. All right?
Yes.
How would you restitute the person? Suppose he wins. How would you restitute if he loses his job? Therein lies the urgency. Have you followed?
Yes.
So tell your senior that he should be ready with the counter affidavit. We will hear it on the first day of reopening.
Okay.
Yes, Mr. Yadav.
My lord, I have no objection. And my lord, so far she is just learning.
No, that's
And
That's
she
right,
should
but
learn.
yes, Mr.
Lordship, there was also notice to the principal concerned, Lordship. And just 1 minute before he informed me that only one indulgence he is praying to assist the Honorable Court.
Only a minute before he informed
Yes,
you.
yes, हम वहीं से हुजूर आ ही रहे हैं.
We put him to notice, ask him to appear tomorrow. What is this?
वो थोड़ा सा उनको असमंजस था कि हुजूर रिसेंटली ज्वाइन किए हैं, रिकॉर्ड नहीं है, बड़ा वो रिटायर कर चुके हैं.
This
थोड़ी
order
उनको
was passed when? It was passed in the month of April.
Only 3 days before notice he has been received, Lordship. That's
Don't,
why.
don't tell me all this that he has informed you only just now. This goes against him.
Obliged. I will correct you.
Yes, Mr. Gyan, why have you not filed your counter affidavit?
Because we have also received the copy of the LP only last week, Your Lordship.
Will you be able to restitute Mr. Yadav?
Lords, since the board conducts examination as direction of the Bihar State, Lordship.
Mr. Shekhar Tiwari, Learned Counsel for Respondent number 5, submits that he shall be filing the response on his behalf by the next date. Stop. So is the position with respect to filing of counter affidavit on behalf of respondents number 1 to 4. Stop. Mr. Gyan Shankar, Learned Advocate for respondents number 1 to 4, states that he has received the statement of facts.
No, I have not received, my lords. Only received the notice only last week, Lordship.
Mr. Gyan Shankar, Learned Advocate for respondents number 1 to 4, says that by the next date counter affidavit shall be filed.
Lords, may I request one thing, my lord? Pray that. Lords, in this case, Lords, the state is also necessary party because, my lords, the board conducts examination whenever the state directs him to conduct. So, the response of the state is also, my lords, necessary
In
in
the
this case.
meantime, the state also to respond to the petition.
Oblige, Lordship.
Notify
Oblige, Lordship.
30th. Re-notify Thursday कौन सा है? Re-notify on 30th of June. 30.
Oblige, Lordship.
04 Mr. Mohammed Harun Quraishi.
Yesterday also he was not there, no?
Your Lordship.
Yesterday also he was not there. देखिए, nobody appears to press this petition. Stop. Similar was the case when the matter was called out yesterday. Stop. The petition is dismissed for non-prosecution. The counsel for you are for appearing for
On behalf of private respondent, Your Lordship.
number.
Sahab Khan, Your Lordship.
The counsel for private respondent number so and so, however, is present. The petition is dismissed for non-prosecution. The appeal is dismissed for non-prosecution.
06 Mr. Vinay Kumar Misra.
Srivastava.
Yes.
आज सबको डिसमिस करना अपने
People. Prior to coming on the impugned order, Lordship, with Lordship, grace leave, kind leave, I want to pray some relevant portion from the read petition, Lordship.
No.
Firstly, Lordship, kindly turn to
Let us see the order first.
Lordship, Lordship.
You are for the appellant.
Lordship, myself a state Lordship and
You are for
appellant
the?
as a state
You are for the
Lordship.
appellant state.
Lordship.
All right. Who appears for the college, for the Sanskrit college?
My friend Lordship. University is also there.
State Universities Act दे दीजिएगा. Now, where is the counter affidavit?
Lordship. Lordship, on the day the matter was listed before the Honorable Singh Judge, that has been disposed of on the same day, Lordship, without completion of pending. There was no opportunity given to file counter, Lordship. In the present case, Lordship, however, my friend has filed one counter affidavit and supplementary affidavit on behalf of us is also there in view of last order passed by the Summon Court, Lordship.
What have you said in supplementary affidavit?
Lordship, I have said on last occasion, Honorable Court observed that if conditional affiliation to the college concerned may be extended or not, Lordship, that our affidavit is that since the minimum requirement which has to
That's
be
all
fulfilled
right.
by-
You are talking about infrastructure.
Lordship,
You are
Lordship,
talking about the land.
Lordship, Lordship.
Now this school had been running on the same land since 1932. Merely because there is a change in the name of the school, and when there is nothing to say that there is any cloud over the land, then can you make any distinction with Goswami Lakshminath Madhusudan
Lordship,
Sanskrit
Lordship,
College?
that affidavit is there, Lordship. We have clarified the situation, Lordship, by way of our supplementary, Lordship. May kindly be permitted to place the same, Lordship. That is para 7, Lordship.
Yes.
That the proposal of university was rejected by the state government by letter number so and so. I am referring para 7. It is
Yes.
affidavit of 22/9/21, Lordship.
Yes,
in
that's right.
affidavit under in view of last order, Lordship. That para 7, that a proposal of so and so, the office ordered saying memo number so and so under section so and so, the Bihar State University as the college in question did not fulfill the basic criteria regarding the land and requirement of number of teachers, Lordship. Thereafter the above said order, which was challenged by the college in question in CW incident 1 to 1728 3 of the 19, which was disposed of by Dr. So the case which my friend is placing reliance presently, Lordship, the instant appeal has been preferred by the state government against the state order so and so. So far the Goswami Lakshmi, that my friend's prayer presently, Lordship. So far the Goswami Lakshman Madhusudan Sanskrit College concerned, it is stated that earlier the proposal for university for proposal of permanent affiliation was rejected by the state government by the office number so and so, so and so, so and so, under section 21(2)(d) of the state government, but due to lack of sufficient number of teachers. There was only one lacuna, that was insufficient number of teachers. That it is the challenge the Lakshmi Goswami so and so contribute the direction to the state government to take approved fresh decision. There was direction to fresh decision, and we by a connection
That ground is that's absolutely untenable.
to in that very college only one.
Who appears for the university? You have recommended. Now this ground is absolutely untenable. You can't hide behind 21(2)(d) of the State Universities Act. Now land, there is no question, there is no cloud over the title. You are only trying to nitpick, and we will record this in our order.
So far, the Goswami Lakshmi
Take
Mahant.
a decision fast.
So far,
We
Goswami
have
Lakshmi.
followed that state distinction. That
Lordship,
distinction
Lordship.
is absolutely ephemeral.
In that
Mr.
institution only.
Mr. Shekhar Tiwari, you have not followed what the court has said. The distinction which you are trying to make is absolutely illusory.
But earlier,
You are trying to make out a third case by giving that distinction, and we are going to record this.
my friend himself has accepted in their
He has
affidavit.
accepted
ये
nothing.
प्रक्रिया में अभी है, अभी भी एक जमीन लेने की का जो
ऐसा नहीं
प्रोसेस
कुछ कहा है उन्होंने.
बिल्कुल लिखा है हुजूर.
Don't make a wrong statement. He has said that
I am referring from the
just a minute.
Lordship.
He has assured that there shall not be any third party encumbrance on that land, and it has been coming since 1932. The university has recommended. We quite see it is not one of those cases where you would question grant of affiliation only on the ground of absence of land over which the institution stands. This distinction appears to be very ephemeral to us. Perhaps you have not been kept happy by the college, and therefore you are taking a decision.
Their own saying, if Lordship may permit to.
We are dismissing this appeal, and we are recording that you are making your nitpicking, and the affidavit is absolutely undeserved of any acceptance.
In the year.
And what is this temporary affiliation? Take a decision, we are directing. Take a decision, otherwise you stand in contempt. देखिए
ये हुजूर काउंटर एफिडेविट का छोटा सा इनका स्टेटमेंट है. अभी भी कह रहे हैं कि जमीन अपने नाम, एक उन्हीं का वर्ड हम केवल पढ़ दे रहे थे. सब्जेक्ट टू परमिशन पेज 14 पर है हुजूर. इस संदर्भ में स्पष्ट करना चाहता हूं कि खतियान में नामकरण का संशोधन सर्वे के वक्त नहीं कराया जा सका, जिसके कारण आज की तिथि तक भूमि के रैयत का नाम पूर्ववर्ती यानी हरिहर संस्कृत विद्यालय ही है. इस संदर्भ में नियमानुसार सिविल कोड गया में भूमि के रैयत के नाम से संशोधित नाम मन सदानंद गिरी हरिहर संस्कृत विद्यालय के बोध गया के नाम पर.
फिर से पढ़िए. You read for the court, you don't read for yourself.
लॉर्डशिप बिल्कुल सर्टेनली लॉर्डशिप.
जोर से पढ़िए.
इस संदर्भ में पेज 14 लॉर्डशिप. इस संदर्भ में स्पष्ट करना चाहता हूं कि खतियान में नामकरण का संशोधन सर्वे के वक्त नहीं कराया जा सका गया था, जिसके कारण आज की तिथि तक भूमि के रैयत का नाम पूर्ववर्ती यानी हरिहर संस्कृत विद्यालय ही है. इस संदर्भ में नियमानुसार सिविल कोड गया में भूमि के रैयत के नाम में संशोधित नाम महंत सदानंद गिरी हरिहर संस्कृत महाविद्यालय बोध गया के नाम पर संशोधनार्थ अपील दायर किया जा रहा है. That they are saying in year 20.
Have you filed this, Mr.
Yes, sir. It is
Just a minute, Mr. Sundaram.
This is representation. This is representation
No.
filed by the.
That's right. So have you? That's
Yes.
all right. It's a representation. It's not an assurance before this court. But have you filed that proceeding? Have you filed that petition for correction in the name? You're not following what the argument is being made. Are you following what is he saying?
Yes, I am following, but.
So therefore, tell us whether you have filed any such petition for correction. Then what are you following? We are with you. And we are prima facie of the view that the learned single judge is absolutely correct. And the distinction which Mr. Tiwari is trying to tell us is absolutely illusory. And we would not accept it. But once you make a statement that such correction has been asked for and necessary application before the concerned authority has been filed, do we take it that it has been filed? You want to check up? चेकअप करके बताइए, उसका स्टेटस बताइए. Even though no order has been passed, we are at the moment inclined.
Lordship, allow me to say something. That this aspect was taken into consideration by the Honorable Reed Court. That the land of.
We are asking you something else.
Lordship, that is
the Reed Court's order. We are inclined to affirm. But since we are asking you for one thing, would you like to respond or would you not? See, we quite see. आप लोग बहस नहीं समझते हैं. कोर्ट का कुछ ऑब्जर्वेशन होता है तो उसको समझने का प्रयास करें. Either you don't understand or there is some problem, something amiss in my statement.
I understand, Lordship.
इन्होंने आपको ऐसे तो समझाना हाई कोर्ट में. Mr. Please. If you would have followed, you would have made a one-line statement.
I have to check. I have to check.
What has
I have to examine
the affiliation?
whether any application for correction
That is the only answer. The affiliation was not granted to you for the reason that you have less than 10 teachers in the college, and number two, the land does not belong in the name of the institution. Now you convince the writ court that because of non-affiliation, no committee is constituted for recommending the names of the appointees. So it is a conundrum. You don't grant affiliation and you question about lack of infrastructure with respect to teacher. So that has been taken care of by the learned single judge. We fully endorse that view. We are with you. How many times we will say that? Now with respect to the land, over that land, your school was running since 1932. There is no cloud over that land. Only after the revisional survey, the name could not be changed. So this distinction, we do say that this distinction is bad, what the government is trying to make in view of the recommendation of the university, and they're giving affiliation to another Sanskrit college where there were lesser number of teachers. But you have made a representation. आपकी बहस को अगर हम इतनी बार बोलेंगे तो बहुत मुश्किल है. आपने representation दिया है कि necessary correction के लिए हमने application लगा रखी है. वो क्या status है उसका? ये पता करके बताइए. Tomorrow, day after tomorrow, we are granting you affiliation. We are directing them to obey the order of the learned single judge. Otherwise, they shall be in contempt.
Your Lordship, I will convey. But the Lordship, this is the process, time-taking process. It might be. But
have you filed the petition? We only want to know this. Have I asked you to produce the order? Have you undertaken what you have said before? Have you done what you undertook before the authorities? Have you done that?
Lordship,
find out and tell us.
I will check up.
Fast, Mister. You have to take
pass
a
over, only pass over.
Only pass over. If you have filed a petition, bring a copy of the petition. We will confirm this order. We are telling you now. Unless Mr. Tiwari comes up with certain position of law, certain question of law. Find out and tell us whether you have filed any application. All right?
If Lordship's permission, I may point out 179 section of the university. If Lordship permit me, I will.
Yes.
Lordship 79 of the Universities Act. It says the college which before the commencement of the commencers in Darbhanga Sanskrit University Act 1962 were recognized by the Bihar Sanskrit Association, in this case this was recognized, shall be deemed to have been admitted, means affiliated, to the university on the commencement of this act.
We have followed that.
I have brought on record.
We have followed that argument, Mr.
That it was running since 1932.
That's right. If you fail to convince us that you have made necessary application before the concerned authority, then you argue this. Make a statement tomorrow.
The entire exercise now is
No, they are prima facie we find that they are trying to make a distinction which is not there.
Tomorrow.
All right, tomorrow.
Series 7, Mr. Piyush Lal.
You should have come prepared with this, Mr. Satyam Sivam Sundara.
I'm sorry.
Yes.
I have a next representation but not checked up the fact.
I had not seen that representation on the last occasion. Yes.
We have filed this appeal against judgment and order.
Louder, Mr. Piyush Lal. Either you have to raise the mic to your mouth or you have to bend to speak in the mic.
With my lord,
it may be uncomfortable. Yeah, that's a better jugaad that you have done. All right. Mr. Arora, you appear for the respondent, for the employee. All right. The employee has retired. Yes, tell us.
This is an order, appeal against order dated 13/8/2020 passed by the Honorable Single Judge. Now, the writ petition was against the order of dismissal, against the inquiry report, against the appellate order. Now, the Honorable Single Judge by the order under appeal has been pleased to set all of them aside, basically on the ground that the inquiry report is perverse, inasmuch as there is no evidence to sustain the charges against him. Now, consequently, the Honorable Single Judge has also held that the order of dismissal also fails,
The appellate authority's order also fails, apart from saying that it is an order without any reasons. Then, my lords, as a consequential relief, the Honorable Single Judge has been pleased to direct that he should be reinstated along with along with payment of full back wages, my lords. Now, our endeavor in the appeal would be, my lords, to show to my lords that the inquiry report is not perverse. It is based on evidence on records which are not in dispute, and the findings arrived therein are on the basis of evidence, my lords.
Sure.
So, before taking my lords to the inquiry report, may I take my lords to 2-3 documents? They are annexed in the writ petition, on the basis of which the charges were found to be established, my lords.
No, you show us from the judgment first.
Ji.
How has the court said that the findings of the inquiry officer is perverse
My
with
lords,
respect to the charge and the evidence?
My lords will my lords will find it at page 8, paragraph 18 of the order under appeal.
Paragraph 18. We'll also see your whatever document you wish to show to us. We'll see that.
Deeply.
But before that, let us see how the order has proceeded.
And the facts have been dealt in elaborate in the order under appeal, my lords. So I can also read the facts from there, my lords, if my lords.
नहीं आप पढ़िए ना इसको.
Paragraph 19, my lords. Paragraph 18. Just before that, the Honorable Single Judge has considered the law laid down with respect to interference, my lords, by the Honorable Writ Courts in matter of departmental proceeding. Now, paragraph 18
And that's
says,
all right. That's
the
settled position of law. There is no difficulty about it.
A bare perusal of the report of the inquiry officer dated 22/3/2005 demonstrate that the authoritativeness and reliability of prosecution witness number 1, namely.
So therefore, paragraph 17 talks about the position of law which will permit a single judge to interfere with the findings.
And there is no dispute to that proposition, my lords. Now, namely, Preeti Shi has not.
A bare perusal of the inquiry officer demonstrates
that the authoritativeness and reliability of prosecution witness number 1, namely Ms. Preeti Shri, has not only been brought under cloud by the inquiry officer, but the said witness has also been disbelieved, and that is why the inquiry officer has exonerated the petitioner and others from the charges of demanding bribe from the allegationist Ms. Preeti Shri. If that be so, then the other charge regarding petitioner being negligent and careless in not making proper arrangement of police force for effecting delivery of possession and instead submitting a false report for extraneous consideration is also bound to fail, since the inquiry officer has failed to lay his hand on any evidence in support of the said charge, and moreover, he has not congregated any motive attributable to the petitioner herein so as to prove the said charge, apart from him having not found any material to disprove letter dated 9/12/2003 written by the petitioner to Superintendent of Police Bhagalpur requisitioning the police force for deputation on 14/12/2003, as also letter dated 9/12/2003 written to the Subdivisional Officer Bhagalpur for deputation of Executive Magistrate and Armed Forces on 14/12/2003 at 7 am for the purpose of effecting delivery of possession, in pursuance whereof the Subdivisional Officer by order dated 13/12/2003 had not only deputed an executive magistrate but had also requisitioned police force, and copy of the said order dated 13/12/2003 was sent to the Deputy Superintendent of Police Bhagalpur as also to the officer in charge Kotwali Bhagalpur for information and necessary action. Therefore, there is no material, much less any evidence in the inquiry report dated 22/3/2005 to prove the charge level against the petitioner regarding him being negligent and careless, having not made proper arrangement of police force for effecting delivery of possession and submitting false report for extraneous consideration. In fact, it has also been admitted in the counter affidavit filed on behalf of the respondent numbers 2 and 3, duly sworn by the Registrar Civil Court Bhagalpur, particularly in paragraph 8, that the petitioner, upon receiving the warrant of effecting delivery of possession, had sent requisition dated 9/12/2003 to the Superintendent of Police Bhagalpur for deputation of police force, and another requisition was also sent on the same day to the Subdivisional Magistrate Bhagalpur Sadar for deputation of magistrate, fixing the date of execution as 14/12/2003. Hence, this court is of the opinion that nothing remains for speculation, and consequently comes to a finding that there is no evidence on record to substantiate the first charge level against the petitioner to the effect that he had negligently and carelessly not made proper arrangement of police force for effecting delivery of possession, and with intent to defeat the writ had submitted a false report for extraneous consideration. Thus, the finding of the inquiry officer qua charge number 1 framed by the District Judge Bhagalpur, white order dated 23/9/2004.
That's right. So how, do you dispute this factual position that he had made application, necessary application before the concerned authorities for deputation of a magistrate, for deputation of placement of police force?
No.
Police force was not there.
Yes.
So therefore you jump to the conclusion that it was deliberate, it was bad, it was for money. Money part has been disbelieved. Why do we differ?
Now my submission will be, my lords. Our charge is not based that the petitioner just merely wrote a letter dated 9/12/2003 requisitioning the police force. It is based on facts which transpired thereafter, my lords. I'll take my lords to the documents and the inquiry reports, my
Mr.
lords.
Piyush Lal, we know that you have a good idea of service law. Now, whatever happened thereafter, was that put to him under the charge?
Yes. If I may humbly submit, my lords,
How?
yes.
What shows the charge?
Therefore, let me start from 1 or 2, 3 documents, my lords, which have been referred here.
But we will do it, but that is not the way you argue an appeal. Unless you can relate it to the findings of the learned single judge. Now you can take as much time as you want. I am not here, though we sit in appeal, but if the opinion of the learned single judge is not perverse, it is not necessary. It is not a case where the division bench finds nitpicks, finds any fault, flaw somewhere. If the position of law has not wrongly been understood, if the facts have not been properly put in place, or the order is so bad that it should be interfered with, where is the occasion for this court to interfere?
I am deeply obliged. My submission will be if the facts have not been taken into note of.
Sure. Now, please speed up and please enhance your speed and tell us.
3 documents from the writ petition, then I'll take my lords to the inquiry report.
Oh.
Annexure 1 to the writ petition, my lords, at page 25.
Annexure 1 to the writ petition.
Page 25. Now, writ petition, my lords, Annexure 1, page 25.
Yes.
Now, this is an order dated 22/11/2003, passed in title execution case, my lords, passed by 2nd Munsif Bhagalpur. Now, if my lord will come at the little, almost around the middle portion of this order, it says that delivery of possession should be given to the decree holder. As earlier also possession was tried to be handed over, it was not handed over. And then in the last portion he says, I'll just read it, my lord. सुना अभिलेख का अवलोकन किया, अभिलेख के अवलोकन से प्रतीत होता है कि दहानी का आदेश पूर्व में किया जा चुका है, परंतु परिस्थिति में के अंदर आवेदन की लापरवाही खारिज किया जाता है। दिनांक 20/12/2003 को कार्यालय दखल दहानी निर्गत करें। Now this is an order, my lords, there is no dispute. It's a judicial order, again no dispute. Now submission will be that the magistrate said effect
right.
delivery of possession put upon 2012, my lords. Now thereafter, my lords, the my lords will see annexure 2. I'll come to the next page thereafter, my lords, annexure 2, page 27.
Yes.
This is the warrant for decree of possession, my lords. Now, if my lords will see, it is addressed to the Nazir Civil Court at the middle portion, my lord. Nazir Civil Court, Bhagalpur, the name of the owner of the property, my lord. Then it says affection suit. Then date of returnable has been fixed as 20/12/2003. Schedule 1 describes the property where it has to be, which has to be handed over to the.
What are you driving at?
I'm driving at that we say that you went to the spot without informing the decree holder, without informing the judgment debtor, without ensuring that the police was there. For what purpose did you go? It is on record, my lords, that earlier also because of lack of police force, the possession could not be delivered, my lords. This is our charge.
Now look at the charge now. Show us the charge.
एक दो document, only for my satisfaction, my lords. And the next page, my lords.
Don't be under the impression that we are in a hurry. I can see there are lesser number of advocates here. You can argue, but only when it's appealing to the bench.
I'll try to appeal to my lords, but just let me build the case. My lords, now the next position, next page, my lords, page 28. This is the back side of the writ, my lords. Page 28. Front side was at page 27. Back side is page 28. Now it says this is the report by the petitioner. स्थल पर पुलिस बल नहीं है। नाजीर बाबू व्यवहार न्यायालय के साथ वापस चले गए। साइंड बाय द दिस executive magistrate who went there, my lords. Fair enough. The decree holder was not, the police was not there. No factual कोई गलती नहीं है हुजूर, but है कि क्यों नहीं
डिग्री
गए?
होल्डर के बारे में नहीं है यहाँ,
नहीं है ना हुजूर?
ये है स्थल पर पुलिस बल नहीं है, नाजिर बाबू व्यवहार न्यायालय के साथ वापस चले।
Next page. I'll just 2-3 facts, my lords, then I'll take my lords to the inquiry report. Annexure 2. Now here comes his report. We say that this is unauthorized and it amounts to creating orders under Order 21, Rule 97 of the CPC. Now first paragraph में हुजूर पढ़ रहे हैं तो Now, second portion of this page 28, my lords.
Yes.
परवाने में वर्णित चौहद्दी के मुताबिक जब दुकान का पता किया तो विवादित दुकान के आगे खड़े आदमी से पूछा कि
बीबी नरगिस का दुकान यही है?
दुकान कौन सी है? उन्होंने कहा कि जो नरगिस का कोई दुकान यहाँ नहीं है, दुकान 40-50 साल पहले से स्वर्गीय अहमद रज़ा का है, उनके लड़के अहमद रज़ा एवं शरीफ चला रहे हैं। इस बात को पुष्टि गवाहों ने भी किया है। Who is the witness? Who is the witness who has said it, my lords? Now this takes away the entire subject matter of the decree of possession. The court says give possession of shop X. He submits a report that shop X doesn't belong to the decree holder. And this is why we say it has come in the inquiry report that this is creating evidence under order.
ये ठीक है।
अब एक last और हो जो it will be argued by the other side. I'll just show it to my lords. Page 26. इस रिपोर्ट के बाद फिर कोर्ट में क्या हुआ बस?
Yes.
Page 26 is part of the order sheet, my lords. ये next date fixed था हुजूर 20/12/2003. First is a formal order saying कि put up the case on 17/1/2003. Then later on 20/12/2003 the magistrate records नाजीर सदर भेजे के दखल दहानी प्रतिवेदन आज प्राप्त हुआ। दखल प्रतिवेदन से ज्ञात होता है कि डिक्रीदारी उनके कपरदार एवं निहंता तथा सशस्त्र बल की अनुपस्थित रहने के कारण कार्यपालक दंडाधिकारी अपने पदचरों के साथ लाचार होकर बिना दखल दहानी किए वापस आ गए। अभिलेख के साथ संकलन किया जाए। So he accepts the report. He doesn't look into it, doesn't do anything further, and the matter proceeds, my lords. Now then there is a complaint by the daughter of the decree holder. Now on the basis of the complaint, preliminary inquiry was held, and then the charges were framed, my lords. Now if my lords will please to come to the charge, my lords. और वो दो चिट्ठियाँ जो रेफर की गई हैं 9/12/2003 that are annexure 3 series, my lords. He did write letters, my lords. Now the magistrate was deputed. 14/12/2003 was the date fixed. पुलिस को किए और मजिस्ट्रेट को किए। 13 तारीख को मजिस्ट्रेट डिप्यूट हो गए, पुलिस फोर्स नहीं डिप्यूट हुए। He knew it. Why did he go to the spot?
And that's right. We quite see your argument. Let us see the charge now.
जी, now memo of charges annexure 6, my lords, but it is attached to the order number 77 initiating departmental proceeding, annexure 6, page 33.
Yes.
Now this is again important, my lords, because this forms, I'll say this and the charge are one document to be read together. Peruse the inquiry report dated 19.
नहीं पहले यहाँ पढ़िए ना, चार्ज देखें, annexure 6 page 35.
जी, I Ramji Pandey, District Judge Bhagalpur, hereby frame charge against Shri Ajit Kumar Mishra, Assistant Civil Court Sadar Bhagalpur, presently posted as Office Class Munsif as First Bhagalpur, as follows: that you, while posted as Nazir in charge Civil Court Sadar Bhagalpur on 14/12/2003, received writ issued by the Court of Munsif Second Bhagalpur entitled Execution Case 17/99 for making decree of possession of a shop in question in favor of decree holder, but you negligently and carelessly did not make proper arrangement of police force for effecting a delivery of possession issued at the court, and with intent to defeat the writ submitted a false report for the purposes of getting extraneous consideration. Now may I make a submission, my lords? Now this first charge is divided into two parts, my lords. First is negligence and carelessness, went to the police, you are aware that it could not be effected without police. And second is, the second part of the first charge is, with intent to defeat the writ, you had submitted a false report. Yes, false report. Now, just interjecting, my lords, the Honorable Single Judge has not even considered this second part, my lords. I'll take my lords to the order. Now, along with this, if my lords will see the part of order 77, under which he was suspended and departmental proceeding was initiated, my lords.
Where is that?
Page 33, my lords, uske just pehle. This charge is enclosed with this order, so it forms a part of this order, my lords.
Yes.
Peruse the inquiry report dated 19/6/2004 of Registrar in Charge, Civil Court Bhagalpur, made on the allegation petition of Priti Shi sent to the Honorable High Court Patna. Shri Ajit Kumar Mishra.
Your
Nazir-
voice is fading away. Now I need not remind you always. You keep it near your mouth.
Hope
Yes.
I am audible now. I am audible now.
Oh, yes, you are.
Ji. Shri Ajit Kumar Mishra, Nazir, Civil Court Bhagalpur, directed by Munsif 2nd Bhagalpur to execute delivery of possession in favor of decree holder of title execution case 17 of 99. 99. As per report of Registrar in Charge Civil Court Bhagalpur, he along with peons namely Satnarayan Singh, Suresh Kumar and Mohammad Afsar of Civil Court Sadar went to the shop in question knowing the fact that delivery of possession was not possible in such a sensitive place without taking police force, and with intent to defeat the writ issued by the court of Munsif 2nd for execution of delivery of possession, submitted a report on 14/12/2003 in collusion with judgment debtor, whereas they were duty bound to execute the writ issued by the court and accordingly deliver the possession of shop in question in favor of decree holder with help of police and magistrate. It is alleged in the allegation petition of Priti Shi that at the instant of Shri Mishra, the above named peons of civil court who were deputed to assist him demanded extraneous consideration from decree holder for getting the DP executed. Though inquiry officer has given opportunity to him to adduce evidence, but he had not availed the same. Therefore, a case is made out against Shri Ajit Kumar Mishra, the then Nazir Civil Court Bhagalpur, for his carelessness and negligence and deliberate dereliction of duty. In contemplation of the above facts, Shri Ajit Kumar Mishra, who is presently
Just a minute, let me just find out, Mr. Arora, you will have to let me know. Is this person, was any criminal case lodged against him?
My lord?
Was any criminal case lodged against, not in this connection?
No.
Not in this connection.
In any condition. So far my petitioner is concerned, the respondent.
He was never made accused in any case.
Any case.
Why do I get a feeling that I had argued bail for this Nazir or Nazir's father or whoever?
Maybe, my lord, otherwise, if that be so indifferent from this, because so far my instructions are that there is no criminal case, but however, if your lordship feel that, I can certainly ask from my client.
If I may interject, my lord.
Just a minute.
Ajay, sorry.
You see, on the last Wednesday, I had indicated the advocates appearing before this court when I was sitting with Honorable Justice Anil Kumar Sinha. Those were 389 petitions. I had told the advocates that please inform if either me or my senior has appeared in any one of the matters any time. Now they all confirmed and said no, but in one of the orders that I was signing, I found that the case was argued by my senior, so I have kept it for release.
As a lawyer,
so therefore, you have to be careful in letting me know, both of you.
As a lawyer,
then my lord,
it appears that, is he, just a minute, is the father of this Nazir a police officer?
Well, I'm not sure. Certainly.
Because of the name, because of the district,
Maybe,
and because of the court Nazir, I am getting some kind of an impression. If it is not there, then we hear. Then he is somebody else. My memory is failing me then. Of course, not in this matter, but in some other matter.
Maybe. Certainly, when your lordship,
there could be many Ajit Kumar Mishra could be there. I don't know.
When it is coming from your lordship's mouth, certainly I am supposed to make inquiry.
There could be some confusion.
Maybe.
Can you just ask whether he or his father was ever made accused in a criminal case, and whether I had an opportunity to argue you, because otherwise we would not like to hear this. But for this there is no problem. We can decide the matter today. Who will ask? You or him?
Official records I can examine, my lords, and it has come in the order sheet at least in service.
No, that may not be. Mr. Arora, please do the needful. Just ask him whether at any point of time he or his father had engaged me in a criminal case.
He's on mobile. I'll try to contact
him.
Right.
If he's there, we'll check it up now and we'll proceed.
I'll do it. If it is contacted, then
it's the same judgeship where there was a criminal case and I had before becoming judge.
Whenever it is coming to a lordship's mind, then certainly I'm supposed to.
It must be checked up, because only last Wednesday some different set of lawyers, and they said that no, it has never, and somebody was in custody for about 10 years. So I passed an order, but while signing I found that it was filed sometimes back, of course.
In such a reckless way, I cannot reply, my lord, without inquiry and without confirming. My lord, as my client has informed me, he is informed that neither he nor his father has ever remained in any criminal case.
All. Proceed.
Now, my lords, may I now take my lords to the inquiry report, my lords?
Yes, so what the point that you are driving is, with the intent to defeat the writ, submitted a false report. This was not taken into account. This
Yes.
is your
This
first
is the
submission.
second part of first charge. Second charge of demanding bribe on his behest, that has not been proved. We have not proceeded on that basis, my
No,
lord.
no, you're relying on this false report charge.
ये first charge का second part.
That's what I'm saying.
और first charge का first part हो गया negligence and
You
carelessness.
followed that.
जी.
You don't need to repeat what the court says. Now, the first charge comprises two elements. One is negligence and the other is false report. So negligence, it's all right. False report has not been taken into account.
Now I'll take my loss to the inquiry report,
Yes.
and then 2-3 judgments on this regard, my loss.
Yes.
Now inquiry report starts at annexure 8, page 48.
Yes.
Malus, first is other recitals, if I may just skip it, Malus.
Page?
It starts from page 48, annexure 8.
Yes.
Now the opening paragraph, my lords, and at the very top, my lords, will see there are two departmental proceedings. Four, this is against the writ petitioner, my lords, and the other 2nd of 2004 is against the other 3 employees who had gone there.
We are not concerned with them.
We are not concerned, my lords. Now, thereafter there are the recitals, my lords, of the charge against him. Then page 49 is the allegation.
Now let us see what he has said.
Ji.
In the charge, third paragraph, charges against Ajit
is that while he was
negligently and carelessly did not make proper arrangement for effecting the delivery and intent the defeat, submitted a false report.
He has basically quoted the memo of charge, my lords, which
right.
inquiry officer generally does, my lords.
Yes.
Now, if my lords will see his reply to the memo of charge, because that is his defense at the first instance, my lords, which would be relevant. That has been considered at page 51 of the writ petition, my lords.
Yes.
Last paragraph at the bottom of the way. In the show cause filed by Ajit Kumar Mishra, it has been denied that he has acted to frustrate the writ issued by the court of 2nd Municipal Bhagalpur. It is submitted that he has submitted his report rightly and should not be taken otherwise, which would apparent from the act and conduct of the proceeding. He honestly exerted and exercised the execution of writ of DP. It is submitted that while his letter dated 401-402 dated 9/12/2003 addressed to Superintendent of Police Bhagalpur requested for deputation of armed forces on 14/12/2003, and while letter number 402-403 dated 9/12/2003 sent to the subdivisional magistrate Sadar Bhagalpur for deputation of executive magistrate and armed forces on 14/12/2003 at 7 am for the purpose of effecting delivery of possession. It is submitted that Shri Shakil Ahmad, who was deputed as executive magistrate, vide memo number 1341 dated 13/12/2003 of SDM Sagar Bhagalpur, and thereafter he along with executive magistrate had gone to the place of occurrence and found no police force at that place, and after local inquiry by the people present at the spot got the knowledge that there is no shop of BV Nargis, that is decree holder, and further got the knowledge that the shop within the boundary as mentioned in the writ is in possession of late Ahmad Raza since 40-50 years, which has now being run by his son, and accordingly under such situation the proceeding had returned back without affecting the DP. After writing his report on the spot, which was signed by the witness and executive magistrate, had also made endorsement on back of the writ of the DP. It is further submitted that there is no truth in the allegation of demanding money by the peon taking his name, and the allegation against the proceeding is based on hearsay, which has no factionary value nor any punishment can be awarded on the basis of hearsay. It is submitted that the inquiry conducted by the Registrar Civil Court Bhagalpur, no truth has been found in the allegation of demanding and taking money on his behalf by the peon Civil Court Bhagalpur, and further submitted that there is vital lacuna in the statement of LAG as well as witness in support of the fact of demand of taking money. Now, does he explain why did he go to the spot, my lords, when the police was not there in his reply? He is absolutely silent.
All.
Now the charge was that he submitted a false report, my lords. Does it say that my report was correct? Because delivery of possession was thereafter effected during the departmental proceeding itself. Now here is a report that the shop doesn't exist in the name of decree holder. Then is it not a false report, my lords? And I'll take my lords to the provision of CPC. Why we say that he created evidence, my lords?
Yes.
Now, my lords, the first charge has not been proved. I'll skip that portion of the inquiry report, my lords. Now, for this respect to the first charge of negligence and deliberate action, that starts from page 56, internal page 9 of the inquiry report, my lords.
Yes.
Now, considering the allegation regarding negligence and dereliction of duty by defeating the order of the court for execution of decree of possession, that is writ, for DP of shop by breaking lock of the same as described in the writ is concerned, I find that Nazir in charge Ajit Kumar Mishra and his team consisting of 3 persons had gone to the spot with executive magistrate deputed to assist the process of the court without police force, knowing that DP is not possible without police force. In this regard, it has come that letter written for sanction of police force was not issued till 13/12/2003, and there is question that for what purpose the proceedee had gone to the spot. It is the fact that they had gone at the spot and could not comply the order of the court, rather submitted a report after unwarranted inquiry for which the delinquents were not authorized, and this fact shows their intent to defeat the writ issued by the court for the execution of decree of DP. It has been argued on behalf of the proceedee that on letter of SDM regarding the deputation of magistrate, they had gone to the spot with hope that police force would have been present at the spot. It is a fact that Nazir was interested for execution of DP by the court concerned with the help of armed police force and executive magistrate, and until 13/12/2003 there was no order from the office of superintendent of police regarding deputation of police force, and therefore there was no reason to go to the spot but without ulterior motive. Now here is the finding of fact and an inference based on that finding of fact, my lords. That finding of fact is based on evidence.
CPC. Yes.
Ajit, I'm sorry, my lords.
Yes, proceed.
I'm proceeding. Then, my lords, it says, it has also come that the parties concerned have also not been duly informed, nor their advocates have been told to remain present at the spot. Now, if I may just pause here, my lords. And in his appeal before the High Court, he says that I don't have the duty to inform the parties as to on what day the decree of possession will be given. Now, CPC, my lords, if I may submit, my lords.
Yes.
Order 21, Rule 24 is for processes, because this is also a process of the court, my lords. Order 21, Rule 24. Now, my lords, order 21, Rule 25, my lords. If my lords will just have a look of it, that provision. Endorsement on process. The officer entrusted with the execution of process shall endorse thereon on the day on and in the manner in which it was executed, and if the latest day specified in the process for return thereof has been exceeded, the reason of delay, or if it was not exceeded, the reason why it was not executed, and shall return the process with such endorsement to the court. Now, this endorsement is at the back of the writ, my lords. There is no provision to give a separate report conducting an inquiry at the spot, my lords. Now, Order 21, Rule 35 is under which this writ was issued, my lords. Order 21, Rule 35.
Order 21 rule?
रूल 35 इस प्रोविजन के अंदर ये रिट इशू हुआ था जो डिग्री फॉर इमूवेबल प्रॉपर्टी.
Yes.
Then my lords, order 21 rule 97.
That you have seen.
उसके साथ एक और प्रोविजन हुजूर, rule 101. Rule 97 my lords have seen. Then
Yes.
101. All questions, including questions relating to right, title or interest in the property arising between the parties in proceeding on an application under Rule 97 or 99 of the representatives and the relevant adjudication of application shall be determined by the court dealing with the application and not by a separate suit, and for this purpose court shall, notwithstanding anything to the contrary contained in any law for the time being in force, be deemed to have jurisdiction to decide. Now here question of title also gets to be decided by the executing court, my lords. And
Yes.
what is the report? That the subject matter of it doesn't exist.
Well, what else? Anything else?
जी हुजूर, अब now his duties as Nazir, my lords, because he said petitioner's duty as Nazir, because we say कि you didn't carry out your duties properly. For that I will take my lords to the civil Patna High Court civil court rules where duties of Nazir has been mentioned, my lords.
बोलिए.
Rule 42. It says process of every description, therefore this writ of possession is also a process, my lords.
फ्लैग लगा, फ्लैग क्यों?
ठीक है. Yes.
Rule 42. Then Rule 44. Every person on whom a process is to be served or executed shall be described in such manner, my lords. Then 48, 49 are the modes of service, my lords. 56 is proof of service, my lords.
All right.
And his duties, my lord, starts from page, Rule 79. Then Rule 82, Nazir is responsible that process to be served in the same week. So responsibility is his, my lords. Then Rule 68, 86, 68, my lords. Rule 68 also, my lords, just for their perusal, my lords.
Yes.
Therefore, did he go to the court saying that police has not been deputed, please extend the date?
All.
Now, then may I take my lords to the reply of the writ petitioner to these findings, or now
You have made out a case.
and
We will deal with it. You
one-
say that the second part of the first charge was never looked into by the inquiry officer. The same was not looked into by the learned single judge, and therefore with respect to submitting a false report, there is no finding, which also was not discerned by the learned single judge, and therefore even that finding, it had a nexus. Now this is one, and number two, with the conduct and responsibility of a Nazir, this is criminal negligence and not tortious negligence, and therefore that it should not have been dealt with lightly. That's all.
So just at the very opening of what what my lord said, there is a finding of the inquiry officer on second part, my lords, of this Rule 97 वो हुजूर I had not read out in the inquiry report, my lords. If my lords will see, page 9, sorry, page 56 of the writ petition, my lords have seen. Now,
Yes.
ऊपर वाला हो गया, why he went to the spot from the last paragraph of this page, my lords, page 56. From perusal of the report of in charge Nazir in DP, it is clear that he has reported facts beyond his jurisdiction and did not comply the order of the court, making the favor to the judgment debtor. The report of Nazir in charge Nazir in charge Nazir Aziz Kumar Mishra is certainly contrary to his duty and will amount to create an evidence under Order 21 Rule 97 CPC against the decree holder. The said report is undesirable and uncalled for, which defeat the order of the court. Hence, I find Ajit Kumar Mishra is guilty of gross negligence and dereliction of duty. In circumstances, he deserves major punishment except capital punishment of dismissal from service. Therefore, he has given a finding, my lords, and it is finding based on his report and provision of law. Nothing, no further evidence was required for this, my lords. And with respect to negligence, one last submission, my lords. Now, it is not there an absolute.
You have been successful in making out a point that it depends on how we deal with it.
Yes, sir.
Yes.
Now, with respect to first charge of negligence, my lords, now it is not an absolute law that every time the burden of proof is on the prosecution in a departmental proceeding. It will depend upon the charge and the explanation offered by the employee, my lord. Here the charge was you went to the place without informing police, without ensuring police, you knew your position cannot be given without police. What does he say? He said, I had hoped. Rahenge wahan. As simple as this.
All right. Yes.
Judgments, my lord.
Which judgment would you cite?
एक हुजूर वो तो proposition of law में नहीं है कि there is no proposition that there is absolute burden of proof on the prosecution, my lords, in a department.
We accept that. Without any case law, we accept that.
And
it's not a criminal trial.
I am deeply obliged, my lord. और उसके बाद फिर हुजूर I am also agreed with the direction that he should be paid back wages for the entire.
50%.
I'll make my submission, my lords, that
Dipali,
decision.
he has the single
No,
judge.
Huzur, I
no,
have
no,
my,
just a minute. The single judge has departed from Dipali Gundu.
But he applies the principle of Dipali Gundu.
He does.
Now, my lords, my submission will be that those cases relate to labor law under Industrial Disputes Act.
That's right. But it's here is the case. Reinstatement.
Yes, but
if there could be no reinstatement, that ground you cannot. There is a cul-de-sac there. That is. If the order is found to be bad, there was no way in which the court could not have ordered. The principle of no work, no pay would not apply here.
We are not applying that, my lords. Our submission is that under the service rules, there are certain provision which will govern what happens after he has been found exonerated by the court, my lords. Now that has to be followed because that is a service rule which governs.
That's right.
And even I'll place the Constitution bench Supreme Court judgment, my lords.
All right. So therefore, your third objection and primary objection is that notwithstanding the aforesaid finding, the court went ahead and directed for payment of 50% of the back wages. The assessment of or quantification of the recompensation or restitution was without any basis because there is nothing there. The principle of law as has been espoused in a case where 25F of the Industrial Disputes Act has not been followed, it should not have been brought or even if the principle should have been brought, it should have been brought mutatis mutandis and not an omnibus application. And thirdly, that the process should have followed and he skipped that process and directed for payment.
And last is a very, very dangerous thing against us, where he says, my lord, the Honorable Single Judge has been pleased to say that the termination was a victimization.
Where has he said that?
Even if everything goes, my lord, that line is very, very...
no, that's you are reading something else into it.
Where
is that? Shows the order, we'll see.
Last page of the Honorable Single Judge's order, my lords.
Last page of the order.
Page 29, and then right from the very first line.
Another factor to be considered is that the employer is guilty of victimizing the employee or workman, then the court concerned will be fully justified. No, this has reference to direction for payment. The court, don't read something into an order. The court, there is no institutional comment. It only says, now you are reading something more into it. Please don't be so captious.
Malas, then Malas,
please don't be so captious.
I'll change my submission to the effect, Malas, that there is a finding at least, Malas, starts from page line 4. I find that the present case is a case. Any
law, any decision which is found to be flawed Therefore, the court would be justified in making that because of the existence of this flawed decision, the person concerned has been victimized. That does not necessarily there's not an ipse dixit that because of this you are held to be a perpetrator of a problem for your employees. No, this is not what the judgment. In fact, not even remotely you can argue that, and I am surprised this
then my lord,
fecundity of mind in
then my lord,
that's uncalled for.
I take back my
No,
submission.
you don't need to take back. We have rejected it.
Then my
you have a
alternative.
right. You have a right to make a statement. We have rejected it totally. We will not even refer to it.
Then, my lord, another submission on this victimization part, that there has to be a pleading to that effect. There has to be some evidence to that effect.
There is no observation of the bench. It is only in the context of direction for payment of back wages. That's all.
I'll be satisfied if my lord just clarifies that portion, my lord.
We will take your statement. We will say that this objection is absolutely unfounded, reading something more into what is not there, and we will be holding you guilty. I mean, not you. The argument that the argument is absolutely captious, reading something which is not there.
Provided if my lord is not satisfied with my first part.
And in the process we will uphold what you say, that there is no observation of the court, there is no finding of the court of any victimization by the organization.
On merits, my lords. On merits. On merits of the charges.
No, victimization in general. All right. Yes, Mr. Arora.
एक और था उसके रिप्लाई में.
बोलिए भाई, जल्दी बोलिए आप. जल्दी बोलिए.
There is a reply.
20 मील ऐसे बनाएंगे तो बहुत मुश्किल है. बताइए.
There is a reply by the writ petitioner in the memo of appeal, my lords. Certain facts which are out of the record have been brought on record. Now I'll place.
Has it been taken into account by the court, by the learned single judge?
अभी read appeal में हुजूर. Appeal में मेरे.
No. Has it been taken into account by the learned single judge?
नहीं.
Then we will not allow him to raise those points in the appeal. But yes.
Wait, your lordship. My lord, the charges are quoted in the impugn
order. No, answer only. That's all right. We have read that. He has made us go through that.
Very true.
You answer only this.
My lord.
Now, the first part of the charge, the first charge is in two parts.
My lord.
One, he has been negligent by not informing the police. And number two, the report which he gives is an attempt to give a false report.
My lord.
His argument is that this false report was part of the charge, it was inherent in the charge, on which a finding has been given by the inquiry officer. The single judge has ignored that finding and has only limited his focus on the first part of charge 1, that he was negligent, which has been turned down, which has been rejected by taking into account the fact that he informed the police officers, he informed the concerned officer to send the posse of policemen, and on his asking, the executive magistrate was there, who also testified that the police is not here and it cannot be done. This is one aspect of the matter. The second, all these arguments which we have not taken note of, you need not respond. The second is, this is a plausible argument which you must respond. And number two, the duties of a Nazir. Now with that, in that context, he has referred to two things. Number one, when such endorsement is made by the court, when a writ is issued by the court for dakhal dehani, for what is that called, for delivery of possession, then the date is to be fixed by the court. Was it fixed by the court?
That date is not fixed by the court. Generally what happens...
Date is not fixed by the court.
It is under the law also...
Let us see order 21, yes. 30, 24. In fact, that observation was in your favor, Mr. Arora. 24. Padhiye.
With the decree for execution of the document or for, and 34, endorsement of negotiation.
Where the preliminary measure required for
probably you are referring to 35.
No. First read process of execution.
Order
24.
Rule 24, sir.
24. Okay. Yes, madam. When the preliminary measures, if any, required by the foregoing rules have been taken, the court shall, unless it sees cause to the contrary, issue a process for the execution of the decree.
Right? Then
Every such process shall bear the date, the day on which it is issued,
yes,
and shall be signed by the judge or such officer as the court may appoint in this behalf, and shall be sealed with the seal of the court and delivered to the proper officer to be executed. In every such process, a day shall be specified on or before which it shall be executed, and a day shall also be specified on or before which it shall be returned to the court, but no process shall be deemed to be void if no day for it return is specified.
That's right. So this 3 has been substituted in 1977.
My lord.
All right. So this, therefore, the court has to give 2 dates.
My lord.
The expected date of return and the date.
My lord.
Is it there?
Yes.
It was there.
Respected the date for return, that on or before that date it is to be done.
That's right.
Yes.
Not later than. Not later
Not
than
later
it should be
than that.
reported.
Not later than.
And not later than it should be executed.
My lord.
All right. So that date has been given in that report.
That is not given. So far report is concerned.
No. Has the writ, I mean, does the writ bear that endorsement?
Just
now, both
yes.
ways you stand to gain, but Mr. Arora, please let me know what is the factual situation.
It is there, my lord. It is annexure 2, my lord, at page number 27.
What does it say?
It says, जीवल को सुविधा उनके जायदाद दखल दिया और आपको जरिए इस अख्तियार दिया जाता है कोई पाबंद डिक्री हाजा को उससे जो दाद को खाली कर देने न चाहे उनको वहां
मैंने दोनों अप एंड डाउन डेट हमें बता दीजिए.
डेट ऑफ रिटर्नेबल 20/12/2003.
20/12/2003. और शुरू करने का कब है? मैंने when between which period?
It has been issued. Yes, sir. It has been issued on 14/12/2003.
That's the date and time. That is what you're talking is 24/2.
Yes.
And what I'm talking is 24/3.
Yes.
When the returnable date is given, the other date also has to be given, that the process should commence on this date.
That is not specified here.
That's not given. Only the return date has been
given.
So therefore it would be deemed to be the date from when the process was issued, the writ was issued.
Yes.
All right.
Yes.
Now where is the requirement under the law that the judgment debtor and the decree holder has to be informed in writing?
My lord, it is an admitted case that he was informed.
That is, forget about that.
Yes.
We are talking about the requirement.
Yes.
We are talking about the requirement. Admitted fact, Mr. Arora, you would fall in difficulty. Admitted fact is that that Preeti, who had made that statement on whose complaint the departmental proceeding was initiated, she says that the father or Nana, whoever was the decree holder, he was ill and therefore he had gone. So that admitted position is not coming to your rescue. Tell us where is the responsibility. Show us.
So far rule is concerned, which rule he is referring to?
The rules he has said, आपको ज़्यादा पता होगा.
हुजूर अभी तो बहस यही कर रहे हैं. We have to rely on his argument. What he is saying that I am supposed to reply to that.
But anyway, judgment debtor, by practice we know that judgment debtor has, the decree holder has to be informed, otherwise he would be interested. He would identify the property.
That is rule 35, my lords. दोनों को देना है, हाँ दोनों को देना है, रूल 35.
Rule 35 of CPC, Order 21.
हाँ, Order 21, Rule 35, my lords. Where a decree is for delivery of any immovable property, possession thereof shall be delivered to the party to whom it has been adjudged, or to any such person as he may appoint to receive delivery on his behalf, and if necessary by removing any person bound by the decree who refuses to vacate the property. Where a decree is for joint possession, my lords will just 3. Where possession of any building or enclosed is to be delivered and the person in possession being bound by the decree does not afford free access, the court through its officers may, by giving reasonable warning,
where a decree is for the delivery of any immovable property, possession thereof shall be delivered to the party. So if he goes there without the decree holder, Now, who would he deliver possession to?
I'm coming to that.
Yes.
It is an
No, keep this in mind. We'll ask you to argue in the way you want to. Now, that was not done, and the process server, this Nazir, he knew that the decree holder will not be available on that day.
No, I'm just the contrary. I will show the admission that it was known to them, and then the daughter said that my father was ill, therefore I could not appear. I'm showing that.
All right. You show that only first?
Yes. Please, my lord, may kindly come to page number 45
of the writ.
My lord, writ application. This is the deposition.
Page number 45.
45, my lord. Internal page number 10 of that annexure. It is fifth line from top, my lord. It is the deposition of the daughter. मेरे अधिवक्ता को इस बात की जानकारी थी कि 14/12/2003
I don't have the page before me. Is that the handwritten thing that you're reading?
My lord,
it's a type.
It is type copy, my lord.
Page 45.
कहाँ पर है? उनके बताने पर ही कहाँ पर है? हाँ, मुझे नहीं मालूम से आप पढ़ रहे हैं?
जी नहीं, हम आई एम कमिंग टू पेज नंबर 45 माला फ्रॉम फिफ्थ लाइन फ्रॉम टॉप
जी।
मेरे अधिवक्ता को इस बात की जानकारी थी कि 14/12/2003 को ये लोग सरजमी पर आने वाले हैं। 13/12/2003 को ये लोग सरजमी पर आने वाले हैं। 13/12 को ही रतन बाबू को जानकारी हो गई थी। रतन बाबू इज द लॉयर। 14/12/2003 को ये लोग आने वाले हैं कि जानकारी घर पर ही मालूम हो गई थी। So she also knew, not only the lawyer, but she also knew. मैं भी वहां मौजूद थे, वे भी वहां मौजूद थे।
ये पढ़ना बड़ा मुश्किल है
जी।
ये जब रिपोर्ट जब लिख रही हैं तब कहती हैं कि मेरे अधिवक्ता को इस बात की जानकारी थी। ये अगर
ये डिपोजिशन में है ना?
नहीं, ठीक है।
So far this part is concerned that the decree holder was not aware of the date fixed with regard to delivery.
किसे देता वो डिक्री, वो जो एग्जीक्यूट करके दखल देहानी किसे दिलाता?
Decree holder, because it is being said that I was being represented in that execution case. This is also mentioned.
And where was the occasion to give a report that this shop doesn't belong? I mean, normally this was decided by a civil court. He is nobody to make a report that shall not be taken into account. But what makes him say so?
I am coming to that part. So far that part is concerned, that it is also not in dispute that he had duly informed to the SDO, to the superintendent of police by giving letter that the police force and the magistrate is required. Pursuant to that letter itself, the magistrate was present on the spot.
You're right. We have said that. We have found out.
One thing. Now, as he says that he was not knowing that police will not come, and therefore he should not have gone over there. My lord may kindly appreciate that the police was informed, the superintendent of police was informed, the SDO was informed, then the police will reach at the site. And only after reaching over there one can know that whether the police is reaching or not. Once the magistrate has come.
No, you take that argument in a different context. The question is that there could be negligence, no doubts about it. But this negligence was while discharging his duty as a Nazir, but no criminal negligence.
At the same time, my lord, at the same time, if your lordship will
he
again.
Was not very diligent. There can be no two opinions about it.
At the same time, my lord, one thing more, the second part of the first charge which my learned friend is arguing, your lordship will find, if I am permitted to read one sentence once again, but you negligently and carelessly did not make proper arrangement of the police force for affording the DP, for effecting the DP issued by the court and with intent to defeat the writ submitted false report for the purposes of getting extraneous consideration. This is the last line. The complete sentence is that. So my intention was that I should get a gratification. And it has been, and that was charge number 2. I am, my lord, it is at page number 29 of the impugn order, my lord, itself.
Yes.
Sorry, page number 3, I'm sorry. Page 3 of the impugn order itself.
Yes, पढ़िए बोलिए.
Well, I'm reading, my lord, the first charge, to save your lordship's time, from 6th line. But you negligently.
Page बताइए एक मिनट.
Page number 3, my lord, of the impugned order.
Page?
Page number 3 of the impugned order, which is.
नहीं, वो writ से दिखाइए.
Writ से, जी.
Page 35.
Page 35 is
Page 35, memo of charge.
Yes.
Ji. Now, my lord. It is, here also it is 5th line, my lord. But you negligently and carelessly, first charge 5th line. But you negligently and carelessly did not make proper arrangement of police force for effecting. So this is in connection with this, that you did it negligently and carelessly. You did not make arrangement of the police force first for effecting the DP issued by the court, and with intent.
That's what he's arguing, Mr. Arora. Now, therefore, your answer is, and I can only think of one answer here. I mean, it's absolutely, I mean, I don't restrain myself from speaking out our mind, that maybe for the benefit or for disadvantage to the parties, we don't know. But he says the second part is an independent charge inside the first charge. Though the charge making body has not been careful, there should have been an independent charge, that he was careless in not making proper arrangement of police. That's one.
Yes.
And number 2, with the intent to defeat the writ, submitted a false report.
Yes.
Now, the only argument which can be against this argument is that this expression, submission of false report, is with respect to the non-reaching of the police authorities, and not with respect to report regarding that the shop was not to be identified. यही जवाब हो सकता है, और कोई जवाब नहीं है. Otherwise the charge would have been in a different head.
One humble submission more, my lord. So far the carelessness is concerned, that is connected with the last portion of that charge. Carelessly did not make proper arrangement of the police force for effecting the DP issued by the court,
and submitted a false report. We have followed that.
For the purposes of getting extraneous consideration. So this was the second charge. So that's why rightly the impugned order, the learned writ court has said that.
So therefore, without even taking extraneous consideration,
my lord,
only for the purposes of defeating the claim of the decree holder,
my lord,
the statement was made which was not within his domain, to say that there is no shop.
My lord, now so far that part is concerned. With regard to that, my lord, there is no charge first of all. Number 2, my lord.
That's his argument. We quite see there is no charge, there is no separate charge.
Yeah, and the second part, my lord, that so far that is concerned, there the Nazir itself was not alone, and so far the identity of property, it generally happens, because whenever what happens, my lord, that whenever decree is issued, although it may be out of the record, but as a civil lawyer, I have every experience of this, that what happens, that is despite everything, because identity of the property as given in the DP, that is essentially the first and basic requirement. So it is required. So whenever it is so, that the Nazir is not supposed to effect the decree. I'm not saying in this case, but in general I'm saying.
This is a self-defeating argument, Mr. Arora.
I'm not saying.
If the identity of the property had been given for the writ to be executable,
my lord,
then he was nobody to say that it is not to be found. Number 1.
I'm not going in that. Just that's why I have said, with liberty of your lordship, I have said that I am saying not only this record, in general what my experience is, what I am saying. Yeah. But so far this is concerned, in this case that is not the charge. With regard to that, it is not being said that you have said wrongly. So only thing was that I did not make arrangement of the police. That has been proved to be false, because this fact is not being denied even by the state, by the appellant, that the letter was given,
and ultimately delivery of possession was given.
Yes, it happens, my lord. In many cases, my lord, the DP goes once, twice, thrice. It happens.
It's nothing unusual. I am also a witness to it. Under the orders of High Court, I had gone as an advocate commissioner.
My lord.
long time back.
Well,
The property belonged to an advocate of this High Court. And the moment I reached there, from a distance I saw that they were boring, members of the public, and they started throwing brickbats. So I just came back, reported the matter to the High Court that it can't be.
So this happens. So I am not saying that particularly for this case, but so far that we are in fact we are confined to the charges that the charges.
All right, yes. Anything else that Mr. Arora you would like, Mr. Piyush Lal? Though you have made valiant efforts, we are not inclined to interfere with the order.
Yes, my lord.
Likhiye. Heard Mr. Piyush Lal for the appellant and Mr. G.S. Arora and Senior Advocate for private respond number for private respond number 1. The respond number 1 was subjected to a departmental proceeding for having shown negligence in executing the writ of the court for delivery of possession in favor of the decree holder, and that also for extraneous consideration. That also for extraneous consideration. It would be necessary, for disposing of this appeal, to extract the exact wordings of the charge which was handed over to the respondent to answer to. The charge number 1 declared that while the respondent was posted as Nazir in charge, Civil Court, Sadar, Bhagalpur, on 14/12/2003, and received a writ issued by the Court of Munsif II, Bhagalpur, entitled Execution Case number 17 of 99, for making delivery of possession of the shop in question in favor of the decree holder, he negligently and carelessly did not make proper arrangement of police force for effecting the delivery of possession issued by the court, and with intent to defeat the writ, submitted a false report for the purpose of getting extraneous consideration. And charge number 2 is that at his instance, the peons, namely Satyanarayan Singh, Suresh Kumar Singh and Muhammad Afzar, all of Civil Court Sadar, Bhagalpur, made demand of rupees 20,000 as bribe for effecting the delivery of possession in execution of decree as mentioned in the charge. The inquiry officer Where is the inquiry report, Mr. Piyush Lal?
That Malos will find at Annexure 8, page 40. It starts from page 48.
The inquiry officer No, where is the inquiry report of the registrar?
That is not on record, my lords.
Where is it? Have you brought on record?
That is not.
मुश्किल है. क्या लिखा है? The inquiry officer, namely the registrar civil courts Bhagalpur, how do we know how the where is the inquiry report? How do we get it? How has the district judge relied upon that report?
Complaint by Preeti Shi that was directed to be looked into.
मुश्किल है तो inquiry report लगाएंगे ना.
If my lords wants to peruse that report, I can get it, my lords.
इसका क्या लिखा है वो देखना था. वो लिखा है कहाँ पर है? किस पैराग्राफ है? क्या लिखा है? What did I say? फिर से? Submitted a report that the respondent was guilty of negligence, but there was nothing on record to indicate that he was instrumental in asking other peons to demand for some consideration for executing the delivery of possession. The disciplinary authority accepted the report of the inquiry officer that there was no demand of bribe for executing the delivery of possession. But the negligence of the respondent was writ large, and considering that the respondent was a Nazir who is responsible for executing the writs of the courts, had acted negligently, held him guilty with a punishment of dismissal, The aforesaid order of the disciplinary authority found waiver with the appellate authority, whereafter the respondent approached this court by CWJC number 13158 of 2006. It was urged by the respondent before the London single judge that with his exoneration of the charge of abetting the demand of money from the decree holder for delivery of possession, no motive could be imputed to the appellant, to the respondent, for having deliberately avoided the execution of delivery of possession. With respect to his having been found to be negligent, it was argued that the learned Munsif to Bhagalpur had, by his order dated 22/11/2003, had directed for effecting the delivery of possession with a returnable date on 20/12/2003, for which the respondent received authorization on 2/12/2003. On 20/12/2003, it was further argued that the parties to the proceedings had filed their attendance, but the matter was adjourned for 17/1/2004. But later, on the same day, that is on 20/12/2003, on receipt of a report dated 14/12/2003, it was reported by him. It was reported that neither the decree holder nor his representative were present on the spot, and the police force was also not there. However, it was brought to the notice of the Munsif, learned Munsif, that the executive magistrate had been present there, in the absence of the police force, the delivery of possession could not be executed. It was also pointed out by the respondent before the London single judge that the respondent had made requisition for police force on 14/12/2003. Earlier, a letter in that regard was also sent to the Superintendent of Police Bhagalpur on 9/12/2003. The subdivisional magistrate Bhagalpur 9/12/2003 which was transmitted to the subdivisional magistrate Bhagalpur also, on which communication an executive magistrate was deputed by order dated 13/12/2003 for facilitating the delivery of possession along with the police force. When such a report was perused by the learned Munsif, no fault was found, as it often happens that not on all fixed dates delivery of possession is always executed. However, the respondent was subjected to departmental proceeding on the complaint made on behalf of the decree holder that without ensuring the presence of police force and without intimating the decree holder or the judgment debtor, the respondent had proceeded to the place with the sole intention of defeating the writ. It was thus sought to be inferred by the respondent before the learned single judge that in the absence of extracting any extraneous consideration, he could not have been blamed for any criminal negligence or submission of a false report regarding non-execution of the delivery of possession. The aforesaid arguments were rebutted by the appellant before the learned single judge, and it was argued that all that a writ court was required to see was whether there was procedural regularity in conducting the proceeding and whether the respondent had been given ample opportunity of representing his cause. Beyond this, the writ court ought not to go into the sufficiency of reasons for holding a delinquent guilty or for finding fault with the quantum of sentence imposed on such a delinquent. It was thus urged before the learned single judge that if there was no procedural irregularity in the departmental proceeding to which the respondent was subjected, there was no requirement of any interference. The learned single judge, after referring to various case laws, ब्रैकेट में लिख देना, after referring to various case laws bracket BC Chaturvedi versus Union of India and others, 1995 6 SCC 749 sub bracket में लिखना. Union of India versus HC Goel, 90 AIR 1964 Supreme Court 364 semicolon. Lalit Popli versus Canara Bank and others, 2003 3 SCC 583. M.V. Bijlani versus Union of India and others, 2006 5 SCC 88. And Union of India and others versus P. Gunashekaran, 2015 2 SCC 610. Found that the findings of the inquiry officer, as also of the disciplinary authority, as also the opinion of the disciplinary authority, deserved interference. For the reason that the findings of the inquiry officer, which was accepted by the disciplinary authority, was found to be perverse, as it was based on no evidence. The grounds for the learned single judge, the grounds which weighed with the learned single judge, was that the charges of demanding bribe had fallen to the ground in the absence of any evidence, and therefore the subsequent charge of being negligent and careless in not making proper arrangement for police force for effecting delivery of possession was also groundless, for there was no reason except for extraneous consideration that such negligence would have deliberately been shown by the respondent in his capacity as in charge Nazir. That the respondent had written a letter on 9/12/2003 to the Superintendent of Police Bhagalpur seeking police force as also the communication made to Sub-Divisional Officer Bhagalpur for deputation of executive magistrate and armed force on the day when the execution was to, on the day when the delivery of possession was to be executed, was good enough evidence in the absence of any rebuttal by the appellant to disprove the charge of negligence. To disprove the charge of negligence. To disprove the charge of negligence, that the sub-divisional magistrate was available on the spot, who also endorsed that the delivery of possession could not take place because of absence of police force, was a further evidence in favor of the respondent that there was no negligence on his part. First off, on these two grounds, the learned single judge found the report of the inquiry officer as well as the decision of the disciplinary authority, as well as the decision of the disciplinary and the appellate authority to be totally flawed, and therefore he in his wisdom set it aside and directed for payment of 50% of the back wages in view of the superannuation of the respondent by that time. Mr. Piyush Lal, yes?
This is 100% back wages, my lords.
50% था ना?
नहीं हुजूर, देखा जाए ना, page 29, the last page, my lords.
Oh, 100% दीजिए
जी,
उन्होंने.
हुजूर.
Pay back wages and 100% back wages and 100% back wages. I thought 50%. This is what you were saying somewhere. 50%. Did he say that
वो
or
हुजूर,
not?
वो उसमें है, दीपाली गुंडू वाले में कोट करके है.
क्या लिखा पढ़िए? The aforesaid decision was taken by the aforesaid decision was arrived at by the learned single judge on the strength of the judgment of the Supreme Court in Dipali Gundu Survase versus Kranti Junior Adhyapak Mahavidyalaya and others, 2013, 10 SCC 324. Mr. Piyush Lal, learned advocate for the appellant, has challenged the aforesaid judgment on several counts. He has argued that the learned single judge was not correct in holding that in the absence of the proof of the charge of demand of extraneous consideration / bribe, the charge number 1, namely negligence, also fell to the ground. Stop. It has been submitted that charge number 1 was distinct from charge number 2, and not interdependent. He has further urged that even in charge number 1, there were 2 charges, namely showing complete negligence in not taking appropriate measures for requisitioning police force, but also for submitting a false report in order to deflect the course of justice. In support of the aforesaid contention, Mr. Lal has drawn the attention of this court to the report of the respondent Where is that report?
Page 28 of the writ petition, my lords, annexure 2.
क्या लिखा पढ़ो? to the report of the respondent which he had submitted before the court after the delivery of possession could not be executed. Stop. The report inter alia states that at the place, the police force was not available. Stop. The decree holder, namely Jugal Kishore Gupta, and his clerk and his advocate's clerk were also not found present. On further inquiry by the respondent, he learnt that the decree holder had gone for medical treatment to Patna. He did not stop there. Mr. Lal has carefully taken the court to the further part of his report, which indicates that the respondent tried to locate the property but he could not. He is reported to have asked a person standing in front of the disputed shop who is said to have told him that no shop of Bibi Nargis is available, but the shop in question was being run for the last 40 to 50 years by the sons of Ahmad Raza, which fact was supported by some of the other witnesses. Though presumably, decree of possession was not effected because of the absence of police force. But the respondent making such endorsement of not locating the property /shop and reporting about the local evidence that the shop did not belong to Nargis Bibi but was being run by others was simply unwarranted. It was in this context, it has been argued that the charge of submitting a false report was laid on the respondent over and above the charge of negligence in not arranging for proper police force for executing the writ of the court. It has further been argued on behalf of the appellant that under the civil court rules of High Court of Judicature at Patna, proper procedure has been delineated for processes and process servers. Section 49 of the rules referred to above clearly indicate that when a summons or notice is served personally, the service and the signature or thumb impression of the person served on the back of summons or notice should be proved, and in the case of defendant or judgment debtor, his identity should also be proved. his identity should also be proved. It has been submitted that in any case such endorsement ought to have been made by the respondent on the writ, and there was no necessity of giving a separate report, which fact only demonstrates that there was an attempt on the part of the respondent to furnish a false report, This aspect of the matter has not at all been taken note of by the learned single judge, and without any cogent reason, it has been held that the inquiry report as also the decision of the disciplinary authority and the appellate authority are not based on any cogent evidence. Lastly, it has been submitted that the learned single judge adopted the principle enunciated in labor laws for restituting the employee whose termination has been found to be incorrect or bad in the eyes of law. He further submits that the judgment which has been relied upon by the learned single judge was in the context of not following the statutory provisions under the Industrial Disputes Act with respect to the requirements under section 25 FF. Section 25 FF. He has further submitted that even with respect to payment of wages, even with respect to payment of back wages, there have been change in the stance of the judicial verdict, and unless it is proved that during the period of termination, the delinquent employee was not gainfully employed, an omnibus order cannot be given for payment of entire back wages. For entire back wages. The onus, though, is on the employer in the first instance, but once it is rebutted, once such a contention is rebutted, the onus shifts on the employee. The learned single judge therefore did not take into account that there was no argument raised on behalf of the respondent that he remained idle for all this while, and therefore the employer / the state did not have any opportunity to rebut the aforesaid contention. In that factual scenario, directing for payment of entire back wages for the period that the respondent was not in service is not justified. Lastly, it has been submitted that the learned single judge ought not to have expressed the necessity of restituting the respondent by directing for payment of back wages for the period that he was not in service, by holding that it ought to be done wherever an employer is guilty of victimizing the employee or workman. Mr. Lal submits that an organization like the judiciary would never victimize its employees, and only because the conduct of the respondent was found to be absolutely below board, comma, he was thrown out of service. He was thrown out of service. Stop. As opposed to the aforesaid contention, Mr. Arora, learned senior advocate, has drawn the attention of this court to the communication made by the respondent with respect to requisitioning of the police force as well as deputation of the magistrate. As well as deputation of the magistrate. The magistrate was there on the day when delivery of possession was to be effected, but there was no police force. He further submits that there was nothing on record to indicate that the respondent had not done his part of making necessary requisition for the purposes of ensuring manpower at the disputed place for seamless delivery of possession. He further submits that the learned single judge was absolutely justified in holding that the respondent was not negligent in background of the fact that the accusation slash charge of demand of money as bribe for effecting delivery of possession having been found to be not proved even remotely. There could not have been any reason for the inquiry of reason for the respondent to have not executed the delivery of possession, in the absence of any motive for not doing so. He has further submitted that though there could have been some lapses in not informing the decree holder and the judgment debtor prior to proceeding for execution of delivery of possession, but that by itself would not make any deficient act of such a kind which would incur the epithet of criminal negligence. The inquiry report and the decision of the disciplinary authority appears to have been based on a finding that there was criminal culpability on the part of the respondent for not effecting the delivery of possession on the day when it was so directed by the writ court. He further submits that it is not very uncommon that on the date fixed, delivery of possession is not given, which could be for myriad factors and not necessarily an intention of the process server slash nazir to defeat the writ of the court. In the present case, there is nothing on record to indicate anything otherwise. Had the respondent not performed his part of the obligation, the magistrate, the executive magistrate would not have been there. The learned single judge was absolutely justified in holding that with the endorsement of the learned subdivisional magistrate, that the delivery of possession was not possible in the absence of police force, nothing else could have been read into the conduct of the respondent. In the respondent. Stop. He has further submitted that in all such writs for execution of delivery of possession, the property is specifically identified and the date on which such delivery of possession is to be executed and the latest return date and the last return date is also indicated. Stop. In the order in the writ of the court, comma, the returnable date though was mentioned, but the date on which but the date on which such process could have been taken in the first instance was kept open-ended, comma, which only meant that it could begin or executed any day after the passing of the writ, passing of the order, any day after the passing of the order. So far as the reasoning given by the counsel for the appellant, that charge number 1, which also has been found to be groundless in view of charge number 2 not having been proved, comma, contained a subcharge of submitting a false report, comma, Mr. Arora submits that such reading of the charge, such reading of the article of charge would amount to writing a new jurisprudence in the service law, as the respondent was never subjected to such charge in the manner in which the appellant is trying to demonstrate. Stop. If at all charge number 1 included the accusation of submitting a false report, comma, it only referred to the report regarding non-execution of the writ for delivery of possession for the reason of absence of police force and not anything else. Stop. He further argues that notwithstanding the fact that the respondent exceeded his mandate in making observations in the endorsement that he could not locate the property, comma, that cannot be taken to be a false report, as delivery of possession can only be given if the property is located. A Nazir knows that when there is a judicial order and a decree in favor of a person, comma, such observations at the time of executing the delivery of possession would not in any manner dilute the directions of the judgment and the directions of the civil court. Such a statement in the report cannot be read or termed as submitting a false report for the purposes of defeating the claim of the decree holder. Had it been so, or would have been understood to be so, comma, it would have been good enough ground for constituting a separate charge for creating a false document or submitting a false report. Stop. Thus, the contention of the respondent is that the aforesaid ground of the appellant for assailing the order of the learned single judge is only the fecundity of his imagination, or else the respondent would have been confronted with that charge of submitting a false report. After having heard next, Mr. Arora has further contended that because the termination of the respondent was found to be bad in the eyes of law as not based on cogent evidence, it was not unjustified for the learned single judge to have directed for restitution of the respondent by directing for payment of back wages. The argument of Mr. Lal that the principle of labor law was made applicable in a case of service jurisprudence is unfounded, as the judgment relied upon by the learned single judge primarily deals with the rights of an employee vis-a-vis his employer. Thus it has been argued that the learned single judge nowhere went beyond record in setting aside the decision to dismiss the respondent and restitute him with payment of full back wages. Lastly, it has been submitted that assuming that the appellate court may hold a different view, but unless it is demonstrated that the view of the learned single judge, which is under challenge in the present appeal, is so perverse that it cannot be allowed to remain on record, no interference ought to be made. After having heard the learned counsel for the parties, we find that the learned single judge has carefully gone through the evidence and was right in holding that there was nothing on record to dispute the fact of the respondent having made necessary arrangement for procurement of police force and deputation of magistrate on the day when the delivery of possession was to be effected. Though the learned single judge though the learned single judge may not have gone in detail with respect to the contents of charge number 1, which according to the learned counsel for the appellant contained another invisible charge which was equally important to be decided, but on a careful analysis of the evidence before us, we are of the considered opinion that if at all the report of the respondent with respect to identification/location of the property was unwarranted, it was only with respect to non-delivery of possession on that date. It would be too much to read that such a report was made or such an endorsement was added in the report for the purposes of creating a false evidence of the decree of the civil court being in any manner doubtful. Stop. Even otherwise, if that were the intention while framing charge, comma, it could not have been left so much under wraps that the respondent would never get an opportunity of confronting it. Stop. As far as direction to restitute the respondent with full back wages is concerned, we are again of the considered view that in the absence of the appellant, in the absence of the employer having proved or even initiated a discussion with respect to his gainful employment during the period of his remaining out of service, comma, the decision of the learned single judge cannot be discounted on any score. For these reasons, we do not find any reason to interfere with the judgment of the learned single judge. Stop. The appeal is dismissed, but without any order as to costs. Limitation we have lie open. IA number so and so. For the reasons stated in the application. IA number so and so. For the reasons stated in the application, the delay in preferring the appeal is condoned. The application stands allowed. But Mr. You made good efforts, but that, I'm sorry, we can't sustain it. Yes, Mr.
Malice, there is one more submission.
Yes.
Where my lords have recorded my submission with respect to payment of back wages. My lord has been pleased to record that I have submitted that it is in context of section 25.
You don't say that.
No. The section 25 FF of the ID Act. My prayer is that along with it, section 11A of the ID Act.
25 FF and section 11A of the ID. All right.
एक और था हुजूर, अब बोला जाएगा
तो ऑर्डर हो गया. We are not inclined to interfere.
खाली बस एक छोटा
we will record it.
वही बैक वेजेस में हुजूर, बैक वेजेस इज फ्रॉम द पीरियड ऑफ डिसमिसल टिल ही गेट्स रीइंस्टेटेड. यहाँ पे पीरियड ऑफ सस्पेंशन का भी
सब खत्म हो गया. सस्पेंशन भी खत्म हो गया. You read that provision in the CC Act.
उसको बैक वेजेस में उसको सैलरी फॉर द पीरियड ऑफ सस्पेंशन करा दिया जाता.
तो ठीक है, it doesn't matter.
उतना कर दिया जाता.
It doesn't matter. वो सब बैक वेजेस की सैलरी हो गई.
क्योंकि प्रिंसिपल डिफरेंट है मेरे सबमिशन से.
नहीं, इसलिए that distinction is not going to make any it's not वो कहना कि for वो suspension order, that period of suspension, then the single judge should have said that the period of suspension be treated as an actual service and then payment.
वो चीज नहीं करे सर. सर्विस रूल्स में है कि
it's not required.
It should be wholly unjustified. That is the only ground which I am trying to add.
No. Where? How do you say?
Rule 97 बिहार सर्विस कोड. अगर फाइंडिंग इनका अगर हुजूर एक स्टेटमेंट भी हो कि it is unjustified, I will draw. And if there is any finding by the honorable single judge, Rule 97.
No, we will give a finding in appeal.
Huzzur, that I can't stop my lord. But
we at times meander with division bench powers and single judge power in the division bench, and that's permissible. That's not my imagination. That's permissible. Yes.
Rule 97, Bihar Service Code, my lord. He was suspended under Rule 96 of the Bihar Service Code. This governs his service condition.
कहाँ चला गया वो बिहार सर्विस कोड? उधर पेज बताइए ना. 97 ऊपर का पेज बताइए. 93 of 1. खाली जजमेंट सब रखता है. Yes, read that.
When a government servant who has been dismissed, removed or suspended is होना चाहिए, छूट गया हुजूर, is reinstated, authority competent to order the reinstatement shall consider and make specific order regarding to pay and allowances to be paid.
Give me 1 minute.
I'm sorry. The authority competent to order reinstatement shall consider and make specific order A regarding the pay and allowance to be paid to the government servant for the period of absence from duty and whether or not the said period shall be treated as a period spent on duty. 2 is important, my lords. Where the authority mentioned in sub-rule 1 is of the opinion that the government servant has been fully exonerated, or in case of suspension it was wholly unjustified, the The government servant shall be given full pay and allowance to which he would have been entitled had it यहाँ पे had होगा had he not been dismissed, removed or suspension as the
ठीक है,
case.
this covers no section
Where
2.
is the finding, Malas? My submission is
We'll
कि it was हाँ हुजूर कर दें. And second submission is Malas that it's for the authority competent to decide at the first instance. वो जो हुजूर दीपाली गुंडू देखा जा रहा था, they were all against orders of tribunal under labor law जहाँ evidence had been led.
All right.
Where is the statement here that he was not gainfully employed? At least वही हुजूर देखा जाएगा तो.
The authority competent to order the reinstatement.
That
So
is the
therefore this is
disciplinary
under
authority.
the orders of the court. So instead of ठीक है, we will deal with it. We'll deal with it. लेकिन the ऊपर में ये इनके argument का जगह कर देना, मैं जगह बता दूंगा. Mr. Lal has further submitted that the learned single judge has directed for payment of back wages without holding whether the period that the respondent remained under suspension be treated as period in service, and the period during which he remained out of service be also treated similarly. First up, he further submits that such decision should have been taken, thus such decision ought to have been taken by the competent authority. First up, without there being any discussion in the order of the learned single judge, the directions for payment of back wages would therefore only mean back wages from the time when the respondent was dismissed till the time when he would have superannuated had he not been dismissed. He further submits that Rule 97 of the Bihar Service Code, Rule 97 of the Bihar Service Code specifies that when a government servant who has been dismissed, removed or suspended / reinstated, the authority competent to order reinstatement shall consider and make a specific order regarding the pay and allowances to be paid to the government servant for the period of his absence from duty, and whether or not the said period shall be treated as a period spent on duty. And for that it is required to be held that the termination was absolutely unjustified. We have taken note of this submission made on behalf of the appellant, but we find that when the learned single judge has found the termination order to be absolutely unjustified, and which opinion has been endorsed by us, it goes without saying that the entire period that the respondent has not remained in service is required to be treated as if in service. First off, we further clarify that the respondent shall be entitled for full wages. Have you prayed for it?
Yes, madam.
Full wages even for the period of suspension, during for the period of suspension pending departmental proceeding. We say so for the reason that we don't find any reason we say so for the reason that we find the order of termination of the appellant, which was directed in the departmental proceeding during which the petitioner remained suspended, to be absolutely groundless. Yes.
Obliged.
Next.
Select Mr. Manoj Kumar.
Yes. समय खो गया आपका सुना अरे Yes, Mr. Verma.
May I please your lordship, my lords?
What is this?
This is an LPA, my lords, against an order passed by Honorable Single Judge, whereby, my lords, the termination order passed against the petitioner has been set aside and he has been reinstated back in service.
कल करेंगे. We'll hear you tomorrow.
My lords.
Yes, Mr.
Yes.
You are appearing for the respondent.
Yes.
Come on tomorrow. We will hear you.
Your lordship, item number 4 DFD हो गया है उसमें.
Item number
4.
What?
DFD हो गया है उसमें, उसका पासवर्ड कर दिया जाए कल का.
Item number 4 हमने DFT कर दिया है. वो हटा दो. पासवर्ड हो जाए.
सब किताब रहेगा. बंद कर दो।
एक नंबर सही है, ठीक है, 2 नंबर सही है। एक से कितना किलो से देख लो ना,
24 तक जाना हो
जी 24 तक नहीं हो। हाँ, तो उसके बाद ये है, रुको सही, ये कितना नंबर किलो कौन है? ये सब कुछ चल रहा है। बाना सूत्री से 26 सीटें तो बोला कितना था? हाँ लगा मिला था 54 तक मिला हुआ। अरे ये क्या कीजिएगा, ये उल्टा पुल्टा है वो, जैसे वैसे छोड़ दो, तो मानना पड़ेगा ना, छोड़ दो ना। बांध सही है कि नहीं रखना?
ठीक तो है ये, इतना बेकार है कि पूछ है। बोर्ड नहीं है, खाना तो यही नहीं खत्म हुआ था। ठीक है, ये वाला दे दो।
इसमें लिस्ट वन सिंगल लगा दिए हैं।
दिया ना 230 तक लिया ना मांग के। फाइल देने गए हाँ?
call PC Echo. PC Echo.
तो प्रोविजनल मिला हुआ है खाली कंफर्मेशन के लिए, ट्रायल को प्रोविजनल दिए हुए 6 तक अपील। तो बताइए ना, जो 6 को बंदे रहेगा कोर्ट कैसे क्या होगा, जो करें। हाँ 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 मेंशन ही तो लोग सुनते ही नहीं है, और सुने और कि यहाँ भी वही हाल, बता नहीं छुट्टी में बेचारे को निकलेगा क्या होगा। इसी के यहाँ तो पहला सप्ताह है। हाँ सागर के पास है, देखिए। हाँ तो सीनियर सबसे यही ना, लेकिन अभी तो आया नहीं, आ गया ना कल ही वाला लिस्ट में देखिए ना। फर्स्ट वीक में ऐसा 6 या 7 साहब हैं, सेकेंड में मात्र 2 गो। सीनियर तो यही हो गया, आशुतोष बाबू, आशुतोष बाबू हैं, सुधीर बाबू हैं। फर्स्ट हाफ में सर जो फर्स्ट वीक में जो निकलेगा और नहीं तो हम लोग चलेंगे पवेलिया। सेकेंड हाफ में तो सेकेंड वीक में 2 गो है, थर्ड वीक में इसकी पुराना केस ना ये तो नहीं है। वो तो कह रहा है पोर्टल बंद रहेगा, क्या करेगा तो पता नहीं क्या आता है। तो लिस्ट में देखा जाए ना इसका। हाँ
सर आज वाला लिस्ट निकला हुआ है, तो पढ़े हम लोग उसका नोटिफिकेशन पूरा निकाले हैं आज वाला। अभी आया है क्या वो वैकेशन वाला क्या आया?
फर्स्ट वीक में सीनियर मोस्ट आप ही हैं। आप ही पर देखा, 2 स्लिप ले लीजिएगा। हमारे पड़ोसी जानते हैं, सबसे मतलब ख़त्म आदमी हमारे पड़ोसी हैं, हम क्या बताएं। और सब पे एक्सेप्ट करते हैं, हमारे पर पता नहीं क्या इनका होल है। कहे कि चाय पिलाते हैं, काहे चिंता कर रहे हैं। यह देखिए अब नाश्ता कैसे वाला है?
चाय तो ऐसी पिला देगा नहीं
कोई बोला। हाँ
करने करते
तो पहले तो हम करेंगे, तो प्रयास करेंगे सर।
तो सबसे ज़्यादा बिगाड़ दीजिए
कैसा
रिजेक्ट होगा तो सबका
जैसे हमारा 99.9% के अलाउ हो जाएगा सर, इसलिए कि हमारा प्रोविजनल मिलल है, कंफर्मेशन का बात है, सीरियल नंबर है 3640 इन्हीं के कोर्ट में, इसलिए हमारा ये वाला बात नहीं है सर कि बिगड़ जाएगा। अच्छा आप आ जाइए, सीनियर आप हैं, आप आ जाइए, उसमें कोई बड़ा बात, उसमें कोई बहुत बड़ा बात नहीं है सर।
हमारा 498 हस्बैंड है, चाहता है रखना भी और 1 टाइम भी चाहता है, जोन चाहे
तैयार है, यहीं पर है।
हाँ चाहे 1 टाइम ले ले, मंथली ले ले, या चाहे
जो ले ले।
हाँ इसलिए
मेंशन नहीं है भैया,
खाली है
ना सर, बचने में दिक्कत है सर, जगह में भीड़ लग जाएगा सर, नहीं समझा गया। ये आप सबसे सीनियर हैं इसलिए आप
खाली है तो
सर 2 मिनट के नहीं है, बैठे सो भलाई है, मतलब बैठे लागे जगह, बैठे लागे तो जीवन पर है ये। अब बैठे बीच में भाई लोग 5 गो आ जाएंगे तो न किसे कहें कि भैया तो देखिए ना, हम आपको दिखाते क्या लेता है परेशान। 2 मिनट में सर खाली मोबाइल देखिए, हम आपको दे देते हैं। जैसे हम डाउनलोड कर देखिए सर, फर्स्ट वीक में हो गए आशुतोष बाबू हो गए, सुधीर बाबू हो गए, उसके बाद हो गए अरविंद श्रीवास्तव साहब हो गए, अनिल कुमार सिन्हा हो गए, उसके बाद हो गए सर आपके जाके प्रभात कुमार सिंह हो गए, नमित कुमार पांडे हो गए, संदीप बाबू हो गए, उसके बाद सतवत वर्मा हो गए और राजीव राय हो गए फर्स्ट वीक में। सेकेंड वीक में मात्र 2 आदमी है। उसमें हो गए सर आपको मधुवेश बाबू सीनियर हो गए और उसके बाद नवनीति कुमार पांडे हो गए। थर्ड वीक में हो गए सर आपके मोहित कुमार सीनियर हो गए, उसके बाद ये पार्थ सारथी हो गए, उसके बाद हो गए सर वर्मा हो गए, राजेश वर्मा हो गए, 3 गो नहीं एक और ये हरीश बाबू हो गए। और चौथा सप्ताह में हो गए आपको जाकर के राजीव रंजन बाबू हो गए सीनियर, सुनील कुमार पनवार हो गए, पूर्णेंदु बाबू हो गए, सतवत वर्मा हो गए, उसके बाद फिर जाकर के राजेश कुमार वर्मा हो गए।
कौन केस रहेगा ये भी
मैं ये तो नहीं कह रहा सर,
उनका तो रहबे करेगा,
बेलवा तो रहना ही चाहिए सर।
नमस्कार साहब, 498 में क्या करते हैं साहब, अगर हम हर कीमत पर तैयार है वन टाइम
कैसे वो ले रही इसलिए बस इतना ही था आपके हाथ। हमारा को आती है अपील है।
हमरा वाला में क्या उम्मीद हो सकता है?
वो तो सर साहब के पास, अब यहाँ नहीं हुआ था तो कहाँ होगा सर? यहाँ नहीं होगा सर तो कहीं नहीं होगा सर। हम लोग जाते हैं ना, यहाँ नहीं हुआ तो कहीं नहीं होगा।
शादी वाला तो
इसीलिए हम लोग सर नाश्ता किए और उसका दौड़
बाद में दे देंगे, फोटो कॉपी भी लगा देंगे, बाद के पहले दे देना, बाद में लगा देना। डेस्कटॉप बात से होगा, पैडिल तो नहीं जाता है, मतलब की है डिजिटल है, पैडिल आता तो
क्या बेकार।
हम तो बड़ी करते रहते हैं।
अच्छा दूसरा चीज़ क्या होता है सर, कभी हमारे जब आपका केस होगा ना तो पता नहीं काहे वो हैंग हो जाएगा, कभी मतलब नेटवर्क हो जाएगा एकदम। एक आध बार ऐसा हुआ, ऐसा सीरियल नंबर 14 मेरा है, 12 तक ठीक है, 13वां में लगा के और उसका देखा थे
मेरा नेटवर्क स्लो, उसके बाद
वही हुआ संदीप कुमार, हम बोल रहे हैं उधर से कुछ नहीं, उधर पास कर
हाँ मैंने साहब को देना पड़ेगा, बोले हैं ले लेंगे।
मेरा राजन
अपील वाला भी लेंगे।
देखिए सर 2 मिनट में कितना बिल हो गया सर।
क्या कर रहे सब वो है बिक्रिया से
अभी ठीक है, माइको ठीक है।
सब तो जल ही रहा है, सब तो ठीक लगता है।
अजीत बाबू को उधर मन नहीं लगा, नहीं नायका बिल्डिंग में आपको मन नहीं लगा, मन नहीं लगता, मैंने आपको उधर मन नहीं लगा, नहीं हाँ
इसका जी विड्रॉल का है ये।
विड्रॉल का स्लिप ले लिए, ले दीजिए। 39 से है, 1 साल और वो अपील है। नौ दिन तो बोल रहे किए थे, 1 साल वाले आप जो भी हैं बेल दे दीजिए।
हम लोग यहाँ सर्वे नहीं करता है, वो सबसे बड़ा समस्या यहाँ यही हो गया कि
नहीं अपने बोले थे उदी कि 1 साल जिनका एंटी से
क्लाइंट का भाग एगो हम लोग यहाँ से हुआ है, स्टे हुआ है, डायरी कॉल पर हुआ था, प्रोविजन बिल मिला है,
विड्रॉ का नहीं है,
बोलेंगे तो विड्रॉल
हमको लगता कि दे रहे हैं।
सब खत्म हो जाता है, सबका
शुक्र के दिन जो बंद हो जाता है, सोमवार से बीफे तक कोरोना नहीं घुसता है, और शुक्र के दिन कोरोना घुस जाता है, कोई बात है भाई? अब पूरा एक दिन बर्बाद होता है, पूरा कोर्ट बर्बाद होता है। बस सोमवार से लेकर बृहस्पतिवार जबकि भीड़ रात में दिन में होता है, रात में वो नहीं करता।
काम कर लेंगे।
आपका कौन सी अपील का एलसीआर आ गया है?
ये कन्फर्मेशन है, ट्रायल कोर्ट बेल दे में। पाँच छः आदमी हैं।
बुरा आदमी बैठे 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 आप आराम से। क्या है
कैसा इसी सप्ताह में कोटे है, अब फिर कहाँ जाएगा, क्या होगा, कौन जाने। देखिए
एक हफ्ता में कितना सुनवाई हुई। फाइलिंग नहीं होगा कोई केस। सुना तो है कि 20 से फाइलिंग होगा। ठीक है। फाइलिंग कोई केस नहीं होगा।
अच्छा, पहले लोग 8 गो 10 गो बैठते थे, इस बार तो 2 गो 3 गो।
किसी का आवेदन थोड़ा बताता है अगर घर खो जाना अब हैंड नहीं है तो हैंड मारना वकील का काम है। को ढेर काम
दो गो स्लिप डाले थे 1 साल वाला, एक ही आया है और 2 स्लिप दिए थे उसी दिन, एक और रिटर्न भाई है ना, इसीलिए एक आ गया है।
चलिए वो क्लियर तब तक।
एक और है, एक तो पहले करनी एक का साल एक और है, 1 साल वाला इसको एक और है।
आने दीजिए। तब पहले हुआ
19 का वासी में
बेल
विड्रॉल का
विड्रॉल दिले रहे
जी अब विड्रॉल आता है ये तो ले
टाइमिंग 10 मिनट बाकी है।
ढाई बजे के पहले नहीं बैठते हैं।
अभी जो बैठे हैं
भैया बहुत पहले से नंबर लगेगा।
हमसे पहले से
भैया के भौजी मारली है आ केसो कर दिली है 498 के।
भैया पुलंका हीरो वाला है।
वो छपरा जिला के।
तीन गो एगो अभी अब बाईबेल वाला वो विड्रॉल वाला है, एगो अपीलों के रखले है। हाँ ये 1 साल हो गए, वो बोले थे ना कि 1 साल वाले जो स्लिप दे दिए थे, 1 साल से ज़्यादा हो गया। तीनों का मेरा फाइल है 15। हाँ
नहीं ना एंटीसिपेटरी वाला सर, एंटीसिपेटरी यहाँ तो एंटीसिपेटरी ना है सर।
यहाँ रेगुलर कहाँ है?
यहाँ रेगुलर जो भी मतलब 1 साल पुराना फाइलिंग है ना वो दे दीजिए। 1 साल पुराना।
पहले बैठ जाते टाइम से तक कितना काम हो गया।
सुन तो रहे हैं।
यही सुना है ठीक है, वो पहले 7 और 20 तारीख से फाइलिंग बंद हो जाएगा। नहीं 1 महीना हाँ कि यही इधर वाला बेलो और वेकेशन में चला जाए। बढ़िया है, पूछो तो झड़ पाएगा।
तो सेंटर दुइयो जज है सेकंड वीक में, थर्ड वीक में 3 गो 4 गो, पहले तो 8 गो 10 गो रहता था सर।
ना 10 गो है पहले,
फर्स्ट में ना, सेकंड में 2 गो। मुकेश बाबू और एक आगे 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 सर।
कहाँ चौकी न चल रही है को?
अरे ऊपर आ गई तो
क्या बोल रहे हैं? माइक पर
केस है। आई हर शर्त पर रखने के लिए तैयार है, मेंटेनेंस भी देने के लिए तैयार है। वन टाइम इसमें हुजूर वारंट निकला हुआ, ये सिपाही है, वारंट उसके प्लेस ऑफ पोस्टिंग
कर सकते हैं। 1 वीक है, अभी कुछ कर नहीं सकते।
हुजूर जेल चला जाएगा।
कब का फाइलिंग है?
हुजूर फाइलिंग का डेट तो नहीं है, लेकिन इसका सीरियल नंबर है 2208 सीरियल।
सॉरी
वो जो ट्रायल कोर्ट प्रोविजनल बेल दे दिया है, वो जो 6/6 को लास्ट।
जस्ट अ मिनट, जितने अपील्स के स्लिप्स हैं सब दे दीजिए।
बेल वाला है हुजूर, 1 साल वाला है।
जी इतनी हड़बड़ी में रहेंगे तो मैं रिजेक्ट कर दूंगा पिटीशन। जो पूछा है उसको पहले कहिए। अपील्स में कौन है? लीजिए मिस्टर वशिष्ठ एंड मिश्रा। इसको स्पेस करिएगा 3 दिन में जितना हो सकेगा। अब 1 साल से जिस केस को नहीं टेकअप किया गया है वो सब दीजिए।
जी
1 बार भी नहीं टेकअप होना चाहिए और 1 साल से कम नहीं होना चाहिए, अदरवाइज द स्लिप विल बी थ्रोन। All right, we will space it in 3-4 days, whatever is possible. All right, now mention.
Lord, may I mention Lord the criminal miscellaneous 6445C of 2021, Lord. The marriage of petitioner from number 2 is fixed on 31st May 2022.
31st of May?
Lord, 31 मई जी।
लगा दी। कौन शादी का कार्ड कहाँ है?
जी लगाए हुए हैं।
किसकी शादी है?
पिटिशनर नंबर 2।
और सब कौन है?
वो 1 मदर है।
देखेंगे कौन सा दफा है?
दफा तो 304B है, लेकिन उसमें हुजूर वो मरी है पेरेंट्स हाउस में, हम लोगों को इम्प्लीकेट किया गया। देख लिया जाएगा हुजूर।
देखेंगे, लगाइए।
फोटो कॉपी कार्ड का?
फोटो कॉपी नहीं, ओरिजिनल कार्ड दीजिए।
हम लोग दे देंगे हुजूर। अभी
आप दे दीजिए तब मेंशन करेंगे।
ये अभी हम फोटो कॉपी हम फिर उसको सबमिट कर देंगे हुजूर।
अगर फोटो कॉपी देंगे तो कल लगा दीजिए।
माय लॉर्ड क्रिमिनल केस नंबर 61829 2021 मिलॉर्ड। ये 302 का केस है। पटिशनर इज अ स्टूडेंट मिलॉर्ड एंड द नेम ऑफ द पटिशनर केम इन लाइट इन द एफआईआर बट 164 का स्टेटमेंट में इन्फॉर्मेंट
मेरिट पर नहीं देख रहे हैं, अभी अर्जेंसी देख रहे हैं। 1 साल क्रिमिनल अपील, बात सुन लीजिए।
ये स्टूडेंट है मिलॉर्ड, इसका एग्जामिनेशन वगैरह होने।
बूढ़ा का नहीं देख रहे,
स्टूडेंट है प्लीज।
सॉरी, एग्जामिनेशन का डेट बोलिए, मैं कर दूंगा। देखिए वकील साहब, कोई जो रीजन हमने अपने कोर्ट के लिए बनाया है उसको डिपार्चर नहीं करेंगे आपके लिए। अगर एग्जामिनेशन का डेट आप देंगे, उसकी डेट शीट देंगे और आप उसमें अपीयर कर रहे हैं, उसकी एडमिट कार्ड देंगे, मैं अपडेट कर दूंगा। 1 साल से आपका केस नहीं सुनवाई हुआ है।
8/10 का फाइलिंग है, 8/10/2021 का
तो सही। अपील में कन्विक्शन हो गया है, बेल रिजेक्ट हो गया है, मैं अपडेट कर दूंगा। लेकिन ऐसे मेरिट पर नहीं कहिए अननेसेसरली।
ये स्टूडेंट है मिलॉर्ड,
कहा तो कि स्टूडेंट का ग्राउंड हमारे नजर में नहीं है, और बीमार है ऐसा कि हॉस्पिटलाइजेशन के अलावा कोई उपाय नहीं है, वो मेडिकल देखते हैं तो हम करते हैं, अदरवाइज 5वां ग्राउंड पर नहीं। चलिए।
May I mention, Lord, petitioner is a lady, my Lord, having two children.
क्या है?
Petitioner is a lady, 2 बच्चे हैं।
दोनों बच्चे लैब में है उसके, 6 महीना 1 साल 9 महीने के बच्चे हैं।
3 साल का है टोटल। नहीं, इसमें है क्या हुजूर, भाई ने केस कर दिया है, इसने अपने शेयर का जमीन
वो तो
बेचा है।
मेरिट का हुआ, जिस दिन सुनेंगे उस दिन बेल दे देंगे।
लेडीज हुजूर 2 बच्चे हैं, दोनों परेशान है, बहुत ज्यादा परेशानी है।
जिस दिन मेरे सामने आएगा और मेरे सामने में
सामने आएगा हुजूर, इसको देख लिया जाए।
आउट ऑफ टर्न बहुत लोग हैं। चलिए।
दोनों छोटे बच्चे हैं हुजूर, छोटे बच्चे
1 साल से कम का बच्चा लैब में हो तो मैं कंसीडर कर सकता हूँ।
3 साल, झूठ तो नहीं बोलेंगे हुजूर, 3 साल का। लेकिन अब परेशान।
इसमें पिटिशनर की माँ का डेथ हो गया है हुजूर, और ये श्राद्ध कम 22/5 को है।
कब डेथ हुआ है?
10 को हुआ है।
श्राद्ध का कोई कार्ड है? डेथ का कोई सर्टिफिकेट है?
न श्राद्ध का कार्ड लगाए हुए हैं।
श्राद्ध का तो आप फोटो किसी समय बना सकते हैं। डेथ सर्टिफिकेट है?
डेथ सर्टिफिकेट हम सॉल्मेंटी में फाइल कर देंगे हुजूर, सॉल्मेंटी में मंगा के।
22 को श्राद्ध है
जी, 22 को।
आप अकेले लड़के हैं?
नहीं, अकेले तो।
एंटिसिपेटरी बेल है, आप जाएं। कौन मना कर रहा है? दफा क्या है?
दफा 307 है, केस एंड काउंटर केस, सिंपल इंजरी है।
इसको हुजूर एक बार जरा
सॉरी, जो नहीं ग्राउंड है वो नहीं ग्राउंड है मिस्टर नील।
इन दिस केस देयर आर ऑल टुगेदर 9 पिटिशनर्स। पिटिशन नंबर 3 का एग्जाम है 20 से, इसका एडमिट कार्ड में लगा दिया हूँ।
किस चीज़ का एग्जाम है? ये
शेड्यूल एग्जाम है एकेडमी BA पार्ट 1 का।
केवल 3 की सुनवाई करेंगे।
307 का सिंपल इंजरी है हुजूर, और मतलब
आउट ऑफ टर्न दूसरे का क्लेम छोड़ के आपका नहीं देखें। यस,
सोल पिटिशनर है हजूर, इसमें एक्साइज एक्ट का केस है, सितंबर का फाइलिंग है लॉर्डशिप। इसमें पिंटू नाम से करीब 4 मुदाले बनाए गए हैं, उसी के तहत।
चलिए, मेरिट पर है।
नहीं जी हजूर, सितंबर का फाइलिंग एक्साइज एक्ट का केस है हजूर, कोई भी क्रिमिनल इंसिडेंट नहीं।
May I permitted to mention case, my lordships. Wife of petitioner died, my lordship. आज ही डेथ हो गया है।
तो आज ही डेथ हो गया है, उसका श्राद्ध वहाँ दीजिए, लगा दीजिए कल परसों। डेथ का क्या है? सर्टिफिकेट कुछ है?
ना,
तब फिर कैसे करेंगे? आप कह दीजिए कोई मर गया, किसी की शादी हो गई, क्या करेंगे? क्लाइंट ही आपको गलत बोल रहा हो तो क्या करेंगे? पता करके
अरेस्ट स्टे कर दिया जाए, केस डायरी कॉल कर लीजिए।
आउट ऑफ टर्न क्यों करें? सबकी अरेस्ट स्टे कर देते हैं, सुनवाई जब होगी तब होगी। ऐसा बहस नहीं किया जाए। कंफर्म होकर बताइए, आपकी स्टेटमेंट लिखाएंगे, चेकअप कर लीजिए, तब बोले।
हुजूर एक पासिंग मैटर है हुजूर,
नो अर्जेंसी। यस,
my lord, anticipated bail applications, 2 bail applications arising out of same PS case number, it may kindly be tagged with each other along with
टैग जहां पर है वहां के साथ
यहीं पर है हुजूर के यहाँ।
ऑलराइट, कितने नंबर पे है?
ये है हुजूर सीरियल नंबर।
उससे क्या फर्क पड़ रहा है? अभी अर्जेंसी की बात कर रहे हैं, जब आएगा, जब टेकअप होगा तब सुनेंगे, मैं फाइल मंगा लूंगा। चलिए नेक्स्ट।
रिलीज ऑफ वकील का मैटर अंडर EC एक्ट माय लॉर्ड।
कहाँ पर है मामला? अर्जेंसी क्या है?
वो 2019 से पेंडिंग चला रहा है।
कब फाइल किया पिटीशन?
हमने फाइल किया 21 में, अगस्त में, सॉरी 7/10/21 को।
बाद में
लॉर्डशिप क्वेश्चन का मामला है ये। लोअर कोर्ट इज एडमेंट टू प्रोसीड इन द केस फ्रॉम द सेम कॉज ऑफ एक्शन 2 केसेस
आफ्टर वेकेशन। यस
माय लॉर्ड, 304 भी है माय लॉर्ड। मदर इन लॉ, शादी है बेटी के।
किसके बेटे? फिर दूसरी बहू को भी मारेंगे?
नहीं, बेटी के शादी है, मेरी सास है। 304 भी है।
बेटी की शादी है?
जी, बेटी के।
कब शादी है?
शादी तो हजूर है 6/22 के,
6ठा महीना में।
जी जी,
छुट्टी मेंशन करिएगा।
एक हुजूर 307 का केस है, केस काउंटर केस है, अपना भाई केस किया हुजूर।
आपने सुन लिया मेरिट
ट्रेडिशनल वेपन है कोई
जब आएगा तब देखेंगे. चलिए कॉल करिए.
And that we mention serial number 1, Mr. Bimal Kumar, urgent hearing.
Yes.
कन्विक्शन है हुजूर 10 इयर्स का. हम कस्टडी में हैं फ्रॉम द डेट ऑफ FIR 11/3/14.
कन्विक्शन देखें.
जी हुजूर.
कन्विक्शन किस चीज
जी
में
कन्विक्शन अंडर सेक्शन 376 ऑफ इंडियन पेनल कोड एंड सेक्शन 4 ऑफ द पॉक्सो एक्ट में. Rather the POXO Act is not be applicable in this case, my lord.
You're in custody since
11/3/2014 from the date of FIR, my lord. I have mentioned in my petition, my lord, in paragraph 18, page 9, main memo of appeal, my lord.
देखिए, Mr. who appears, respond to this. He has remained in custody for 8 years. We are inclined to, prima facie, we are inclined to grant bail. But 389, the requirement is that the state to file response. Okay, let the state file response to the application to IA number 2 of 2019. So the appellant applicant seeks bail during the pendency of the appeal on the sole ground of his having remained in custody for 8 years against a sentence of 10 years for the offence under section 376 of the IPC. Let such response be filed positively by the next state. Re-notify on 24th of June.
एक प्रेयर होगा जो 28 के बाद किसी डेट में रखा जाए, वो फर्स्ट वीक हम नहीं हैं.
29th of June. Sorry, 30th of June. चलिए. Yes.
Serial number 2, Mr. Raju Giri.
Why contempt I have kept? Any reason?
Lordship, I had mentioned before your Lordship.
And what was the urgency?
Lordship, the result is not being published, though there was a direction to publish the result, your
Result
Lordship.
is not being published of what?
Lordship, of the Chowkidars, your Lordship. Already the examination has been held, and as directed by Lordship, we had filed an application on time, stating therein, Lordship, the stages in which the examinations were held, that is Annexure 3 of this contempt petition, your Lordship. And as yet, sitting over it, in spite of the direction of the state government, your Lordship.
Today I have received the instructions, so may kindly granted.
All right.
After
File your
vacation,
response.
maybe, Lordship.
Look here. Let the response to the petition be filed positively by the next date. We are fixing it on the first day of reopening. Re-notify on 20th of June. If you don't come with a specific response, we will direct for publication of result. Yes.
Obliged, Lordship.
Serial 3, Mr. Kamal Kishore Jha.
May it please, Lord.
Yes.
Lord, the conviction is under section 304B.
Yes.
Indian Penal Code, and has been sentenced to RI for 7 years. Now, my Lord, he has remained in custody for about 2 years.
Has the appeal been admitted?
Yes, my Lord.
Where is the order?
The order is, my Lord, dated
Admitted for hearing. All right, all right, all right. Who are you?
I am father-in-law, my Lord. He
Your
did about
father-in-law.
70 years.
How many people have been convicted?
3 persons, my Lord. Father-in-law, mother-in-law, and the husband. Husband has been sentenced for RI for life.
And you have been sentenced for?
7 years.
All right. Response. Respond.
Yes.
See, normally I granted bail in appeal, but many of the orders have gone to Supreme Court of different benches where this response is necessary. Like here, let the response to the petition seeking bail
Lord,
during the pendency of trial
The appellant is ill, my Lord.
be filed positively by 20th of June.
Serial 4, Mr.
And
Anil
it will be ordered, my
Kumar
Lord.
Singh.
The order may be passed, my Lord, so that thereafter it may be listed.
We need 20th of June, it shall be listed, Mr. Pankaj Kumar Sinha. You want a double order? Yes.
May please, your Lordship, the appellant has been convicted, your Lordship, under 20B 2C of NDPS Act for 10 years and 1 lakh fine, Your Lordship. Petitioner custody period is, Your Lordship, 4 years 3 months, Your Lordship. From
कहाँ पर है? Just a minute. Conviction under 30. Where 20, is the judgment?
20.
Where is the judgment?
Your Lordship.
Even CRPC देना था.
LCR has come, Your Lordship.
Let us see the judgment.
Your Lordship, at last page of the 48.
कहाँ? बाप रे, 986 किलो गांजा. एक्साइज थोड़ी NDPS है.
NDPS, yes, Your Lordship. Informant, including other prosecution witness, has categorically stated, Your Lordship.
You're in custody since when?
From 16 to 2018, Your Lordship.
2000?
16 to 2018.
Not now.
Your Lordship, what I am trying to submit, Your Lordship,
Yes.
that the recovery itself has been stated categorically that has not been recovered from my possession or from my house, Your Lordship.
संजय सिंह के घर के बगल में बने तहखाने से और कृष्णा सिंह के मकान के उत्तर पश्चिम वाला कमरा से 30 किलोग्राम. आप योर होम
संजय सिंह.
बगल वाला तहखाना के बारे में कहा है कि it is not.
Yes, Your Lordship, if you already see the
show us that part of the judgment.
Your Lordship, in page 7, para 8, the prosecution witness, the informant has been recorded, Your Lordship. And
page 7, para 8. All right.
It starts from there, Your Lordship, but the relevant one is at internal page 10. Internal page 10, in the middle, Your Lordship. कंडिका 27. कंडिका 27 में कहा है कि सिपाही लोग घर को की घेराबंदी में थे और पदाधिकारी गण घर के अंदर बरामदगी में थे. संजय सिंह के आवासीय मकान से कुछ भी बरामद नहीं हुआ. इस संबंध में मैं संजय सिंह को लिखकर नहीं दिया कि आपके आवासीय मकान में कुछ भी आपत्तिजनक सामान की बरामदगी नहीं हुई. संजय सिंह घर का निकास दक्षिण तरफ है. डिटेल, Your Lordship. तहखाना 2-3 लाइन्स बिलो, Your Lordship. तहखाना में दरवाज़ा नहीं था. वह बिना दरवाज़ा का कमरा था. सोने लायक कमरा नहीं था. वह सीमेंट की चादरें की छत थी. कमरे और मकान के बीच से गली थी. This is the statement of the informant, Your Lordship. Other witnesses have also supported this fact, Your Lordship, that nothing has been recovered from my house, Your Lordship.
You filed separate IE or?
No, this is the first time, Your Lordship. Prayer has been made in that petition, no IE.
Let a response to the petition for grant of bail to the appellant during the pendency of the appeal be filed not later than 30th of June. First off, list this matter on 1st of June.
1st of July.
1st of July. Sorry.
All right.
Cell 5, Mr. Ranjay Kumar Singh, PS correction करना है. PS correction.
क्या ये जो नाम गलत था?
जी. PS का करेक्शन ऊपर में हेडिंग में
क्या है?
हेडिंग में PS का डिटेल गलत है.
ऊपर के हेडिंग में
जी.
PS केस नंबर 259 गलत है.
नहीं, ईयर 2021 के जगह 2019 होगा.
देखिए, this case has come at your instance or at the instance of the petitioner?
Our instance.
This case has come at the instance of the office. Stop. The wrong year of the case has been noted in the heading of the order. Let the concerned assistant in the office be given show cause notice to explain why such mistake is committed, as such mistake cannot be rectified in the order Stop. Any change in the heading, any change in the header is to be carried out by the office only and not by the court staff where the petition is disposed of. Let such an explanation reach this court within a week. आप रिलीज हो गए ना?
नहीं हुआ तो 10th of May order petitioner was granted anticipatory bail by lord, but order has not been pronounced.
चलो ऐसे लिखो. This case has come at the instance of the petitioner. This case has come at the instance of the office. The petitioner was granted anticipatory bail by order dated 11/1/2022. However, it was later found that in the heading, the year of the case was wrongly stated to be 2021, though the case is Raghopur PS case number 259 of 2019 and not 2021. The matter has been brought to the notice of this court for the reason that such correction in the header can be carried out only by the office and not by the court staff of the court, not by the secretary who types the order. Let such correction be carried out by the office with respect to the date, with respect to the year of the case, within a period of 2 days, so that the petitioner takes advantage of the order dated 11/1/2021. The office is also, the concerned assistant in the office is also directed to be more careful in future while entering the case number and other necessary details.
My lord, subsequently on 10th of May, final order has been passed, your lordship.
अरे भाई तो एक बार क्यों नहीं बोलते हो, बीच बीच में बोलते हैं? Modification में इतना समय क्यों लगाएंगे? Final order was passed when?
10th of May, your lordship, but that has not been pronounced, your lordship.
It has not been pronounced.
Yes, your lordship.
हाँ तो ठीक है, तो सब वैसे ही करेगा, करेक्शन कर दीजिएगा, उसके बाद फिर उसको प्रोनाउंस कर. All right.
Oblige.
76, Mr. Arvind Kumar Sinha.
लॉर्डशिप एंटीसिपेटरी बेल योर लॉर्डशिप.
अर्जेंसी है,
अर्जेंट पे चढ़ा था, फिर सीडी मांग के द्वारा जॉइन
केस डायरी मांगा गया था.
नहीं तो केस डायरी के बाद आएगा अपने इससे. अर्जेंसी क्या है? व्हाट इज द अर्जेंसी?
अपने आप लिस्टेड होगा.
काजल कुमारी इज टू अपीयर इन एन एग्जामिनेशन, उनको तो दे ही दिया था.
लॉर्डशिप
देन व्हाट, वेयर इज द अर्जेंसी?
हमने मेंशन नहीं किया लॉर्डशिप, अपने आप आया है आफ्टर रिसीव ऑफ डायरी.
आफ्टर वेकेशन आपको बेल है ही है, प्रोविजनल बेल है. लेट दिस मैटर बी लिस्टेड.
अपने आप लिस्टेड.
ऑल राइट, लेट दिस मैटर बी लिस्टेड पोस्ट वेकेशन इन द फर्स्ट वीक आफ्टर रीओपनिंग. डेट दे देना.
ओके. 7, Mr. Arvind Kumar Singh.
Yes.
1 year have passed since filing of this bail.
For the reason of this case not having been taken up even once for the last 1 year, priority has been given. Priority hearing has been given in this petition. Yes.
Application for anticipatory bail and offense, main offense under section 307 and 354 of the Indian Penal Code, my lord.
Yes.
Case and counter case on filed on behalf of petitioner is first case, my lord. Allegation is that कि informant के husband होली गाते हुए जा रहे थे तो 5 आदमी इंक्लूडिंग petition नंबर 1, 2 and 3 गाली गलौज किए, पकड़ लिए, लपड़ थप्पड़ से मारपीट किए. इसी बीच उनके इंफॉर्मेंट के देवर बचाने आए तो सुरेंद्र पासवान petition नंबर 3 फालसा से हेड पर मारे. उसके बाद नरेश चिमनी पासवान बचाने के लिए आए तो petition नंबर 2 and 3 रड से मारे हेड पर. फिर बचाने उनके छोटे भाई मोहन पासवान आए तो जमुना पासवान ने मारे.
How many persons are injured?
4 इंजर्ड हैं हुजूर, लेकिन इंप्यूग्ड ऑर्डर में आया है कि 2 आदमी इंजर्ड हैं. फ्रैक्चर इंजरी पाया गया है मोहन पासवान एंड चिमनी पासवान.
नहीं तो मोहन कैसी है नेचर ऑफ इंजरी?
नेचर यह फ्रैक्चर है, ग्रीवस है, लेकिन चिमनी पर मारने का सिर्फ petition नंबर 1 and 2 पर है और मोहन पासवान पर मारने का.
कॉल फॉर द केस. हम अभी ये नहीं देंगे, इंटरिम नहीं देंगे. Call for the case diary and list this matter on receipt of the same on 21st of June.
In the meantime, my lord, counter case is also, my lord, on behalf of petitioner, one is also injured, my lord.
No.
And
counter case भी है.
Yes, my lord.
उस केस में accused को bail हो गया है.
ये तो नहीं कह सकते हैं, लेकिन इंजर्ड
Case diary आने दो.
और my case is first case, and thereafter he has.
If there is a grievous injury and more than one person has been injured, we are very careful granting anticipatory bail. We shall only after seeing the nature of injury, if it is not on the vital portion of the body, and in the counter case, if the accused person has been released on bail, we shall grant you bail. That's the standard practice which I have adopted here. All right.
Mr. Ashok Kumar Misra.
May please, Lord.
Yes.
एक साल वाले पे हुजूर आया है.
वही reason दे देना एक साल वाला.
जी. Lord, case is under section 399(402) and 307 of the IPC, my lord, and 27 of the Arms Act.
Yes.
In this case, my lord, the FIR was lodged by the police. May I permitted to only place 3 or 4 lines of the FIR. इसमें हुजूर ये कहते हैं दरोगा जी FIR में कि हमको गुप्त सूचना मिली कि कुछ घटना करने के लिए लोग इकट्ठा हुए हैं. हम जब गए वहां पे तो स्पाई से और अगल बगल के लोगों से ये पता चला कि कुछ क्रिमिनल लोग इकट्ठा हुए थे और आपस में इन लोगों का पैसे का लेन देन के लिए झंझट हो गया, जिसमें ये फर्दर कहते हैं पिटिशनर के बारे में कि सुमित मिश्रा नवीन मिश्रा को गोली मार दिया. नवीन मिश्रा को लोग ट्रीटमेंट के लिए हॉस्पिटल ले गए. यही हुजूर FIR है. नवीन मिश्रा ने हुजूर कोर्ट में पिटीशन फाइल किया है एनेक्सर 2 कि पुलिस आज तक मेरा स्टेटमेंट लेने ही नहीं आई और हमको अननोन लोगों ने मंदिर के पास जब हम घर से जा रहे थे तो गोली लगी है. और नवीन मिश्रा को भी एक्यूज बनाया गया है, अदर्स को भी एक्यूज बनाया गया है. उनका एनेक्सर 2 पिटीशन है.
नवीन मिश्रा को बेल हुआ?
जी नहीं, नवीन मिश्रा को हुजूर बेल नहीं हुआ. हाईकोर्ट कोई नहीं आया. हमको छोड़कर
जापान साहब को भी बेल नहीं हुआ?
नहीं, हमको छोड़कर हुजूर हाईकोर्ट कोई नहीं आया. अभी हम चेक खुद किए थे. हमको छोड़कर हाईकोर्ट कोई नहीं आया है. और नवीन मिश्रा ने पिटीशन भी दिया, ये भी आया है कि उनका
कि 399 402 में मैं तो आपको बेल ग्रांट कर देता. क्वेश्चन ये है कि आपने 99 402 तो पुलिस के लिए है जी. आपस में आप लोगों ने पैसे के बंटवारे को लेकर गोली चलाई जो पेट में लग गया उसके.
नवीन मिश्रा ने
स्टेटमेंट कैसे देगा? वो तो आपका एसोसिएट है.
उसने पिटीशन हुजूर एनेक्सर 2 फाइल किया है कोर्ट में कि मेरा स्टेटमेंट रिकॉर्ड किया जाए.
He is your associate. If he gives anything, if he says that he was there and you fired at him, then he shall never get bail despite the fact that he has been shot.
वो तो कहता है कि हुजूर हम आ रहे थे अननोन लोग हमको मार दिया.
Call for the
डायरी मंगा लिया जाए जी.
Call for the heard Mr. So and so. Call for the case diary and list this matter on receipt of the same on 30th of June.
Oblige, my lord.
Mr. Ranjit Kumar.
1 साल का ऊपर का फाइल है हुजूर. मेन ऑफिस
1 साल से है. 1 साल वाला ग्राउंड. बोलिए.
मेन ऑफिस इज सेक्शन 420, 467, 468, 471 and 414 of the Indian Penal Code. इसमें प्रोसिक्यूशन केस है हुजूर कि इन कोर्स ऑफ रेड और मोटरसाइकिल वाज इंटरसेप्टेड एंड मोटरसाइकिल राइडर डिस्क्लोज हिज नेम गणेश कुमार.
क्या?
In course of raid, one motorcycle was intercepted and motorcycle rider disclosed his name as Ganesh Kumar. And motorcycle, he could not produce the documents of motorcycle. And when वाहन ऐप पर पता किया गया तो मोटरसाइकिल ये दूसरे का था और उन्होंने पिटिशनर का जयंत कुमार का 2 अलग का नाम लिया कि इन लोग चोरी करके लाते हैं हमको बेचने के लिए देते हैं और जयंत कुमार ही बेचने का ग्राहक खोजते हैं. जयंत कुमार को हुजूर ने बेल दे दिया है एंटिसिपेटरी में.
हमने बेल दे दिया नहीं साहब, ये तो बड़ा मुश्किल है. वो तो कन्फेशन पर आपका नाम है लेकिन आप मोटरसाइकिल चोर के गिरोह है.
मेरे यहाँ से रिकवरी नहीं.
रिकवरी से क्या मतलब है? देखिए सर, और कब हमने बेल दे दिया आपको?
4 आदमी का नाम लिए इंक्लूडिंग जयंत कुमार है.
आपके पास से कोई रिकवरी नहीं है?
नहीं हुजूर, मेरे पास से कोई रिकवरी नहीं है.
हर्ड मिस्टर, क्या नाम आपका?
अरविंद कुमार सिंह.
हर्ड मिस्टर अरविंद कुमार सिंह, लैंड काउंसिल फॉर द पिटिशनर एंड सो एंड सो फॉर द स्टेट. The petitioner seeks bail in anticipation of his arrest in connection with so and so. Next, one Ganesh Kumar is said to have been arrested on the charge of stealing motorcycles. First off, after his arrest, he has named few persons including the petitioner as one of the accomplices. First off, it has been urged on behalf of the petitioner that except for the aforesaid confession of Ganesh Kumar, there is no other material to connect the petitioner with the offence. No stolen motorcycle appears to have been recovered from the possession of the petitioner or on his from the possession of the petitioner. Under similar circumstances, one of the accused persons of this case, namely Jayant Kumar, has been granted anticipatory bail by this court by order dated 9/5/2022, passed in criminal miscellaneous number 23951 of 2022. However, aforesaid Jayant Kumar had clean antecedents, but the petitioner appears to have been made accused in two other cases, which fact finds mention in paragraph number 3 of the bail petition. ये सब उसी दफा का है, 392 का है, आपको नहीं दूंगा,
बेल पर है वो।
वो क्लीन एंटीसीडेंट था, उसको दे दिया। ये तो आप पर 392 का मुकदमा है, 483 का है, 484 का है, हर केस में एंटीसिपेटरी बेल ले लें। अब देखते हैं, अब इतना ऑर्डर लिखा दिया, देने वाले तो थे बेल, लेकिन ये एंटीसीडेंट वाली बात दिखकर और उसी नेचर ऑफ ऑफेंस है, डायरी मांगता हूँ। लेट केस डायरी बी कॉल्ड फॉर एंड लिस्ट दिस मैटर ऑन रिसीट ऑफ द सेम ऑन समटाइम्स इन जून कर दीजिएगा, 30 of June. नो इंटरिम प्रोटेक्शन।
Mr. Bipin Kumar.
Please, Your Lords. Application for anticipatory
Why
bail.
urgence?
1 year.
1 साल।
Anticipatory bail, my Lord.
Same reason, yes.
Offence under Section 7 of EC Act, my Lord. It is alleged in the first information report by the district agriculture officer, my Lord, he received information that this petitioner is involved in selling, purchasing of fertilizer.
You are proprietor of Annapurna Fertilizer?
ये अन्नपूर्णा फर्टिलाइजर 2013 तक था हुजूर, मेरा लाइसेंसी थे हम, उसके बाद बंद हो गया। हमने एक फाइल किया है सप्लीमेंट्री हुजूर, इसमें गांव के किसान लोग इस गोदाम का यूज करने लगे, सब अपना अपना खादा और ये रखने के लिए।
कब FIR कब लॉन्च हुआ?
FIR 20 का है हुजूर, पेज 10 पे है हुजूर।
अच्छा,
FIR है 14/12/2020 को, 4 दिन के बाद FIR होता है हुजूर।
नहीं, वो 4 दिन के बाद या 8 दिन के बाद।
हाँ।
लेकिन आपकी लाइसेंस नहीं थी बेचने की।
जी नहीं, वो तो बता रहे हैं हम कि 13
क्या
तक
कारण
थी,
कहते हैं?
13 तक लाइसेंस मेरी थी और गोदाम बना हुआ था गोडाउन, उस गोडाउन का उपयोग करने लगे किसान लोग गांव के हमारे, और उसका सब लोग सप्लीमेंट्री में दिया है कृषि पदाधिकारी को कि रिलीज कर दिया जाए, मेरा है, सब लोग अपने रिलीज के लिए वहाँ पिटीशन लगाया है। कोई क्रिमिनल हिस्ट्री नहीं होगी।
क्या नाम है आपका?
पप्पू
आपका नाम पप्पू
अरुण
तो
कुमार
देखिए
पांडे,
ना,
अरुण
हाँ?
कुमार पांडे।
Heard Mr. Arun Kumar Pandey, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with Section 7 of the EC Act for having stored pesticides and selling the same to people without any valid license. First off, it has been submitted on behalf of the petitioner that the shop of the petitioner, which was being run earlier till the validity and currency of the license in that regard was raided and pesticides were found. It has been urged on behalf of the petitioner that no doubt the shop of the petitioner, that in the shop of the petitioner pesticides were found, but that was not for the purpose of sale. In fact, when the license of the petitioner to deal in pesticides had expired, the petitioner made attempts of renewing it, but he could not. Hence, the space in the shop was used by villagers as storehouse for pesticides. There is no accusation that the petitioner had sold pesticides to anybody, claiming himself to be the dealer. There does not appear to be any complaint of that kind in this regard before the police officer. On the contrary, learned counsel for the petitioner has submitted that several persons have intimated the investigator that few of the pesticides bags, few of the bags containing pesticides belonged to them, which they had kept in the shop of the petitioner. Regard being had to the aforestated facts and taking into account that the petitioner does not have criminal antecedents and he is no longer the licensee for dealing with pesticides, against whom provisions of Section 7 of the EC Act could have been attracted, he is directed to be released 10,000.
Seal number 11, Mr. Ranjit Kumar, number 1.
मैं लीजिए लॉर्ड से
क्या है इसमें अर्जेंसी?
1 year.
498 है 341
1 year वाला कर
323
देना।
हाँ 1
Yes.
ईयर से ऊपर का है 14
बोलिए।
महीना हम ननद नंदोई है
क्या है?
ननद एंड नंदोई
In a case of 498 है
498 है entire family have been made accused husband has also been released on bail
Where is the husband? Where
husband bail हो गया
लिखिए heard Mr.
का दूसरे सबका बेल हो गया है
इन्फॉर्मेंट का अपोज
इन पर केवल एक ही एलिगेशन लगा दिया जनरल तो ये है जो भी है जो हस्बैंड पर है इन पर लगा दिया कि बुरी नजर रखते थे
Heard Mr. Ravi Shankar Sahai, learned advocate for the petitioners, and Mr.
Praveen Kumar
for the informant. The state is represented by so-and-so. The petitioners seek bail in anticipation of their arrest in connection with so-and-so. The petitioners have been made accused in this case because of their being related to the husband of the informant. They're being related to the the petitioner number 1 is the sister-in-law, whereas petitioner number 2 is the brother-in-law of the informant. Apart from the general and omnibus allegation against the petitioners, it has also been charged that petitioner number 2 kept an evil eye on her. The husband of the informant has already been released on bail. Considering the nature of accusation against the petitioner and taking into account that such prosecution was initiated when the informant could not live happily with her husband, and therefore the possibility of false implication of other members of the family of the husband, the petitioners are directed to be released 10,000.
Seal 12, Mr. Shailendra Kumar Jha, 1 year.
1 year.
Take.
498 and 3 and 4 dowry provision.
Were you?
I am the husband, so called husband. Husband नहीं है, ये claim करती हैं कि हम इनके पत्नी हैं।
वो बहस पर तो बहुत मुश्किल है, वो तो डिसाइड करेंगे, देखेंगे, नोटिस करेंगे। अगर आप उससे निगोशिएट करना चाहते हैं तो हम कोर्ट बिलो में भेजेंगे, अदरवाइज नोटिस करेंगे, बेल वेल तब नहीं।
नहीं, नो कोर्सिव तब, नो कोर्सिव कर दिया जाए ना।
देखिए, the petitioner seeks bail, पहला तो लाइन लिखना after 1 year. Heard Mr. Shailendra Kumar Jha, learned advocate for the petitioner and so-and-so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so-and-so. It has been urged on behalf of the petitioner that the claim of the opposite party number 2.
I have not made.
Then we are not doing anything. We are dismissing your petition.
वो जो थी ना है कंप्लेंट
आप ऐसे चश्मा खोल के हाथ से ऐसे पॉइंट आउट कर रहे हैं, कम से कम
नहीं सॉरी
एक तो पिटीशन आपने दुरुस्त नहीं बनाई है।
सॉरी ये एफआईआर है, तो आई मे बी परमिटेड टू ऐड माय लॉर्ड, आई मे बी परमिटेड टू।
ये सब बहस आप कहीं और करिएगा, हाँ, कि एफआईआर है इसलिए 498 है, मैं पार्टी बनाने की जरूरत नहीं है, ये सब बहस करेंगे तो मैं सीधा खारिज करूंगा।
अच्छा, सॉरी, बना देते हैं पार्टी।
The petitioner seeks bail in anticipation of his arrest in connection with so-and-so. It has been urged on behalf of the petitioner that the claim of the informant that she has married the petitioner is bogus. The petitioner denies that he has ever betrothed the informant. The Land Council for the petitioner is permitted to add the informant as opposite party number 2 during the course of the day. Let notice be issued to OP number 2 on steps being taken by the petitioner within a period of 2 weeks, both modes, returnable on 4th of July. Regard being had to the disclosure of the petitioner that he is yet ready to amicably settle the dispute with the informant / opposite party number 2, he is directed to be released on provisional bail on his furnishing bonds in the sum of ₹10,000 with sureties of like amount.
CM 13
पार्टी बनाइए।
हाँ जी पार्टी
बनाइए। 13 में
ये 498 है, मैं ये बहस दोबारा नहीं करें कि एफआईआर है इसलिए पार्टी नहीं बनाएंगे।
ये हुजूर एक साल का है हुजूर, इसमें अर्लियर
एक साल वही लिखा
माय लॉर्ड, अर्लियर जो है 24/3/2022 को पिटिशनर नंबर 2 का हुजूर हम विथड्रॉ कर लिए थे हुजूर।
ठीक है
माय लॉर्ड। ऑफेंस मेन ऑफेंस अंडर सेक्शन 379, 307, 325 of the IPC and other allied sections of the IPC, my lord. In this case, my lord, first information report page
16, my lord. May I permitted to read the first information report,
Yes.
my lord. निवेदन पूर्वक कहना है कि मैं भोलू पिता सोहनसो जिला नालंदा का निवासी हूं। आज दिनांक 24/4/2020 को समय करीब 7 बजे पशु पालन कार्य हेतु भान नंबर सोहनसो से पड़ोसी सुरेंद्र यादव पिता सोहनसो, अजय यादव पिता दुलार यादव, सन्नी कुमार पिता स्वर्गीय अरविंद यादव के साथ चारा लाने हेतु अस्थामा से धोबी बिघा बिचली धारा जा रहे थे कि
how many persons have been injured?
3 persons, my lord. And a matter has already been compromised between the
कैसी
parties.
इंजरी है?
इंजरी हुजूर है इनका एक इंजरी सिंपल है इनका।
ग्रीवस को छोड़ दिया।
ग्रीवियस भी है, एक है ग्रीवियस ग्रीवियस है इनका सुरेंद्र इनका से हुजूर दुलार यादव का जो है ना।
एक सेकंड
माय लॉर्ड।
प्रमोद जिसने पैर तोड़ा है उसकी बेल आपने विड्रॉ कर ली।
माय लॉर्ड।
अब संजीत ने पिस्तौल दिखाया
जी।
दूसरे लोगों ने क्या किया बताइए?
दूसरे लोगों ने हुजूर राहुल जो है सुरेंद्र यादव को मारे हैं, इनका सिंपल इंजरी है। तारी गोप भी सुरेंद्र को मारे हैं। मन्नू जो है अजय को मारे हैं और मनोज भी मारे हैं अजय को, जिनका ग्रीवियस इंजरी है।
तो मन्नू और मनोज को मैं एंटीसिपेटरी बेल नहीं दूंगा।
माय लॉर्ड, रेगुलर बेल के लिए ऑब्जर्वेशन दे दिया जा चुका है।
वो तो
माय लॉर्ड।
देखिए Heard Mr.
Rajkishore Prasad.
Heard Mr. Rajkishore Prasad, learned advocate for the petitioners number 1, 3, 4, 5 and 6. Bracket में लिखना, the application of petitioner number 2 was earlier dismissed as withdrawn. The petitioners, the aforementioned petitioners seek bail in anticipation of their arrest in connection with so-and-so. The Learned Counsel for the petitioners has submitted that though the accusation has been hurled against all the accused persons, but such accusation appears to be highly and overtly exaggerated. There was some dispute between the parties, as a result of which a scuffle took place in which some of the persons have been injured. However, the petitioners number 5 and 6 are said to have assaulted one Ajay, who has received grievous injuries. The assault perpetrated by petitioners number 3 and 4 have only resulted in simple injuries to the victims. So far as petitioner number 1 is concerned, he is said to be armed with a pistol which he never used. Considering the aforementioned circumstances and the nature of accusation, I am not inclined to grant anticipatory bail to petitioner number 5 and 6 who have caused grievous injuries to one of the victims. Their prayer for anticipatory bail is rejected. However, if they surrender before the court below and seek bail, their applications shall be considered on its own merits without being prejudiced by the fact that this application on their behalf has not been entertained. So far as petitioners number 1, 3 and 4 are concerned, regard being had to the nature of accusation against them, they are directed to be released in the event of arrest or surrender 10,000. While saying so, the court has also taken note of the fact that petitioners number 1, 3 and 4 do not have criminal antecedents.
CL14, Mr. Sanjay Kumar for withdrawal.
My Lord, arrested petitioner.
SK alias Sanjay withdrawn.
CL15, Mr. Sanjay Kumar withdrawal.
In this case also petitioner arrested.
CM16, Mr. Vinay Kumar withdrawal. CM17, Mr. Ranjay Kumar Singh.
May I please, Lord, sir? This is appeal against conviction under section 3.
Mike.
My Lord.
Conviction under section 397 and 307.
And 27 of the Arms Act.
Yes.
My Lord. Maximum for punishment is 9 years under section 397 and 307.
9 years for 307.
And along with 397, my Lord. And 5 years for under section 27 of the Arms Act, Your Lordship.
आप कब से कस्टडी में हैं?
My Lord, I have remained in custody more than 4 years and 8 months.
Requirement of notice to state is for 10 years, not below. But still, because you have been convicted, we'll seek a response on your application for bail and then consider. Let the state respond to the prayer made on behalf of the appellants for grant of bail during the pendency of the appeal. List this matter on receipt of list this matter thereafter on 30th of June. उस समय आइए देखेंगे. If they don't file, then we will consider.
Section 18, Mr. Kumar Dhirendra Pratap Singh.
Criminal appeal, my lord, under section 20 or 22
क्या
of
है?
NDPS.
Criminal appeal है. Arjun.
Yes.
20 and 22 of NDPS Act, my lord.
Yes.
Conviction and 10 years, my lord, and fine rupees 1 lakh, my lord.
देखिए,
Petitioner
the appellant stands convicted under section 20/22 of the NDPS Act and has been sentenced to undergo RI for 10 years, to pay a fine of so-and-so, and in default of payment of fine so-and-so. This appeal is admitted for hearing. Call for the trial court records. First up, let the state file his response against the prayer made in the petition for grant of bail during the pendency of the appeal, and list this matter on receipt of the same on 8th of July.
Section 19, Mr. Sanjay Kumar Sharma.
May it please, my lord. My lord, conviction is
Criminal
under
appeal.
Yes.
Conviction is under section 30A of the Bihar Prohibition and Excise Act.
Yes.
The sentence is, my lord, 5 years rigorous imprisonment and 1 lakh fine, and if there is a failure to pay the fine, then 1 year additional, my lord, simple imprisonment. My lord, the appellant is the driver of the offending vehicle.
And what was recovered?
Recovery is, my lord, 576 liters of Indian made foreign liquor.
They have heard Mr. You are Ravish Kumar.
Kumar Ravish, my lord.
You heard Mr. Kumar Ravish, learned advocate for the appellant and so for the state.
My lord, Binod Bihari Singh.
And Mr. Binod Bihari Singh for the state. The appellant stands convicted under section 30A of the Bihar Excise and Prohibition Act 2016 and has been sentenced to undergo RI for 5 years, fine of so-and-so in default of payment of fine. It has been urged on behalf of the appellant that he is only a driver of a vehicle from where 576 liters of liquor was recovered. There is nothing in the judgment which would indicate that the knowledge of the petitioner regarding the presence of the liquor in the vehicle which he was driving could be proved. This appeal is admitted for hearing. Call for the records from the court below. During the pendency of the appeal, the appellant is directed to be released on bail on his furnishing bonds in the sum of ₹10,000, 2 sureties of like on. Pala conviction hai?
Pehla conviction and no antecedent. Fine may also be suspended.
The amount of fine during this period shall also remain. The payment of fine is also suspended. The order directing for payment of fine is put in abeyance.
Section 20, Mr. Deepak Kumar, withdrawal.
You are Deepak Kumar? No. नाम बोलिए ना भाई.
आशुतोष कुमार.
हाँ?
भाई को बोलिए नाम.
आशुतोष
नाम बोलिए.
आशुतोष कुमार.
ये तो और आपको अच्छा से बोलना चाहिए, ऐसे डर के बोलते हैं. Mr. Ashutosh Kumar, on instructions from Deepak Kumar, seeks permission to withdraw this application. Dismissed as withdrawn.
Section 21, Mr. Manoj Kumar, withdrawal.
I withdraw this.
आप मनोज कुमार हैं?
Yes, ma'am.
Withdraw.
Section 22, Mr. Manmohan Kumar, urgent hearing.
जो पिटिशनर नंबर 1 के बहन की शादी है.
क्या है?
पिटिशनर नंबर 1 के बहन की शादी है.
For the reason of the marriage of the sister of petitioner number 1 having been scheduled for.
आज ही है.
तब फिर क्या करेंगे? आज तो आप शादी में चले गए होंगे, आज थोड़ी कुछ
रात में ही है हुजूर.
रात में कहीं अरेस्ट नहीं कर ले, कल कहीं अरेस्ट नहीं कर ले.
अब हुजूर लेट हो गया.
Which is scheduled from 16/5/2022. The matter has been given a priority hearing. चलिए.
My lord, case under section 394/427 of IPC.
Yes.
Petitioner is not named in the FIR, my lord.
How many of you?
2 आदमी हैं हुजूर.
तो दूसरे का क्यों सुने?
तो हुजूर जैसा इच्छा हुजूर.
हाँ?
एक ही का मेन हम प्रेस एक ही का करेंगे, लेकिन साथ में है हुजूर तो.
Very good. But ये क्या है? You are not named in the FIR.
Not named
Then
in
what
the.
happened?
Name petitioner का नाम हुजूर co-accused एक apprehended co-accused सत्य विजय है, उनके कन्फेशन पे आया है.
आप दोनों का?
जी हुजूर. 4-5 लोगों का नाम उन्होंने लिया है हुजूर बस.
जिन्होंने नाम लिया हो गया उनको?
नहीं हुजूर, अरेस्ट हुए हैं, जेल में हुजूर, और 3 आदमी और 2 आदमी और जेल में है हुजूर.
देखेंगे दूसरे वाले का आप भेजना कि उसको बाद में सुने कोई मतलब नहीं रखता. तो अभी मैं डायरी मांगता हूँ कंप्लीट, आपको छोड़ नहीं दूंगा, देखूंगा. Like the petitioners seek bail in anticipation of their arrest in connection with so and so stuff. It has been submitted on their behalf that they have not been named in the FIR and are sought to be prosecuted in this case on the basis of confession of an arrested accused person. Call for the case diary and list this matter on receipt of the same on 1st of July. The petitioners in the meanwhile, in the event of their arrest or surrender, shall be released on provisional bail 10,000. Withdrawal?
Withdrawal.
जी यही अरेस्ट हो गए हैं हुजूर।
आप सच्चिदानंद राय हैं?
जी।
मिस्टर सच्चिदानंद राय।
CL 24, Mr. Pushpendra Kumar Singh, withdrawal.
Lordship is withdrawn.
आपका क्या नाम है? दिव्या भारती?
दिव्या भारती।
MS Divya Bharti, Land Council for the petitioner seeks permission to withdraw.
Under heading for orders, CL 25, Mr. Ranjit Kumar.
Yes.
My lords, yes. My lords, just to speed up the things, my lords. And in view of the second proviso to section 17A, where the tender granting authority, approval granting authority.
Have you switched on the mic? Is it showing red color? Yes, you just have to pull it.
My lords, one supplementary to bring certain records, my lords. And my lords, a short.
Have you given a copy to the vigilance?
Yes, my lord.
A supplementary affidavit.
My lords, yes, copy has been given to the
A supplementary affidavit has been filed during the course of argument. Let it be taken on record.
My lords, I have prepared,
yes,
especially in view of the second proviso to section 17A, my lords, a short chronological facts which will give your lordships enough indication that time period.
Give a copy to him also.
My lords, yes.
Yes.
My lords, that the time granted to the approval granting authority is for some purpose. Otherwise, my lords, the authority would have been given a copy of the source complaint and then he would have had to decide automatically. My lords, first let us now, my lords, I have given your lordships 3 judgments I have read before your lordships. The long and short of the 3 judgments are, my lords, if 2 views are eminently possible, then the one which tends to check corruption is to be adopted. Second, 17A has to give a narrow interpretation. A narrow interpretation.
No. Yeah, this I would stand corrected if I am wrong. But it says that it could be given narrow and wide interpretation depending upon the circumstance. That's what the court says.
My lords, then they said, my lords, your lordships are right. I was only referring to that decision of the Supreme Court which talked about when it tends
as you have made the court note down even points which are against you. So therefore, it is the duty of the court to point out.
My lords, I stand corrected, my lords. Now, my lords, let us see the FIR, my lords.
Yes.
My lords, the FIR, your lordships will find, starts from page 20. Now, my lords, kindly see the FIR, first page of the FIR itself.
Yes.
My lords, will come to the वादी का नाम, परिवादी का नाम. Can you see that?
बोलिए.
ये है स्रोत, source. Has your lordship got that at page 20?
At page 20.
No, criminal writ application, my lord.
Yes. The yes, Srot.
Shrot is a source information. Now, my lords, we'll kindly turn to page 25, my lords, for the simple reason that, my lords, the first page is of the FIR is posted later in your lordship's record, and the second page a page earlier. At page 25, I'm reading it, my lords. It has been credibly learnt that A1, Dr. Rajendra Prasad, that's the petitioner before your lordship, while working as Vice Chancellor Magad University, Bodh Gaya, entered into a criminal conspiracy with Sri Subodh Kumar A2, private firms namely Mr. Purva Graphics, Messrs. X LICT A3 and A4, Sri Om Prakash A5 and C. Jitendra Prasad A6, and unknown others, and in pursuance thereof, fraudulently and dishonestly cheated that government of Bihar to the extent of rupees 20 crores, approximately, during the year 2019-2021. What follows, my lords, your lordships will kindly make a note of it. In the matter of purchase of various items related to the use of university during examination and otherwise. Lords, possibly I will not have to show anything more but to say they were the official duty to be discharged by the Vice Chancellor, which he says also in the next second paragraph. It is further alleged that for purchase of material, there has to be a requisition, tender, and so far as feasible, the material should be procured through GEM. GEM is Government E-Marketplace. After attending all the codal formalities, a proposal to this effect was brought to the notice of A1, the petitioner, who was the authority competent to pass such order for payment based on the recommendation. Therefore, my lords, the second paragraph of the FIR itself for the written report talks about I am a competent authority, competent to take a decision on it. My lords, I am only trying to refer that. Now,
you're only trying to bring it in line with the requirements under 17A and the protection therein.
My lords, I will show the counter affidavit para 12 after this. What is, my lords, the scope of investigation even as per SUV? It is alleged that ignoring the advices of the competent officer, A1 directly entered into criminal conspiracy with A2 and A3. Because it should be A3 and A4, they are the publishers, to raise bill to the extent of 20 crores from Magad University and Veer Kunwar Singh University, both without assessing the requirement. Because will kindly make a note of it, assessing the requirement and violating the tender procedure and justification of rates, etc. He was also holding the charge of Veer Kunwar Singh University. Reportedly, all the materials, including books, are lying idle without use. No record, it's a page before, my lords.
Yes.
No record was submitted by the accused parties regarding the quantum of supply, etc., but fraudulently entertained all the bills to facilitate payment in pursuance of criminal conspiracy. It is further alleged that a strong objection note was put up by the officers dealing with financial matters, as well as then Vice Chancellor of VKISU, Veer Kunwar Singh University also, but they were ignored from their respect. It is alleged that two officers, namely A5 and A6, were pressed into service, because these are the post of financial advisor and registrar who are appointed by the Chancellor, who cleared all the fraudulent bills of A3 and A4. It is further alleged that A1, in consonance with the aforesaid accused person, connivance with the aforesaid accused person, has acquired huge movable and immovable properties at different places by using aforesaid modus operandi. And as such, the aforesaid accused persons are also responsible for the abatement of crime. The fact mentioned discloses offense under so-and-so, 120B, 420 Indian Penal Code, read with section 12, read with section 32, read with section 13(1)(b) of the PC Act. Milords will turn a page earlier is the office order, by which, in terms of provision of section 17, an officer has been authorized to investigate offences under the Act. Because that is the intent of the office order at page 23, saying, my lords, that this requires investigation. My lords, I am invited, even if 17A was not there, a matter relating to corruption on source information, without even, my lords, for a moment taking note of the Constitutional Bench decision in Lalita Kumari case, as reported in 2014-10 SCC page 40, if I am correct, or page 1, either of them, 1. Now, at para 120, they set out and say in such matters, including matrimonial, corruption, a preliminary inquiry. Now, my lords, in this aspect of the matter, your lordships will keep in mind the modus operandi period is said to be 2019 to 2021. While I was Vice Chancellor, and the person competent to take a decision and pass the bills, it is exercise in placing orders for materials and other things to be used in examination of the Magad University. Therefore, my lords, no imagination is required, no further process of thought being put in is required when the source information, which they record as a written report for the purposes of instituting the case, itself indicates that these are acts relating to official discharge of function, and decisions have been taken by me, and therefore, my lords, the rigors of 1718, my lords, I put a question to myself, my lords, where was the difficulty in having obtained that source information to seek a permission from the competent authority? The competent authority in such a matter, my lords, not being unknown. It's covered under the statutory provision of Bihar University Act. Under section 10(2), my appointing authority is the Chancellor. My lords, in this context, before I take your lordships to these facts, and then a couple of judgments will follow, and that will be all for the purposes of the criminal writ. My lords, kindly turn to counter affidavit para 12 filed by the SU.
Counter affidavit.
Counter, my lords. That's a rejoinder, my lords. Counter is one without an iksha, my lords. They have referred to the paragraphs of the case diary. as if
Yes.
at page 25.
$25.
25, no, para 12.
Yes.
That the petitioner has been making conscious and deliberate effort to obfuscate the entire issues with the purchase of answer sheets in place of OMR question booklets. First, my lords, they say is that the petitioner, possibly reading my writ application and various contention, that answer sheet could be OMR and OMR question booklets are two different things. And I am trying to, my lords, confuse the issue and trying to take shelter of OMR answer sheets purchased earlier to mislead the Honorable Court as the purchase of answer sheets meant for written examination in not the subject matter of investigation for now. Therefore, my lords, purchase of answer sheet by my predecessor, Vice Chancellor, is not a subject matter of investigation, which becomes manifest from the averment made herein below. The decision regarding purchase of answer sheets for written examination to be conducted by the Magad University had been taken during the tenure of earlier Vice Chancellor Mr. D.P. Tiwari, which is not connected to fraudulent payment related to OMR question booklets to the tune of rupees 15.55 crore. At present, the scam, not with pardon such words, either you have investigated it well. Now suppose if one was to allege, my lords, it's a COVID period, 2019 to 2021. No, your lordships introduced virtual courts. Your lordships introduced e-filing. And could one turn back, given these circumstances? And I will indicate that it is pursuant to UGC SOP that OMR question booklets were resorted to, approved by the syndicate, apart from syndicate, approved by the academic examination committee, board of examination, approved by the syndicate, approved by the chancellor. In fact, goaded to entertain that particular course. I have given that short notes today. At present, the scam, the word scam, which took place during the tenure of period related to fraudulent payment of rupees 15.5 crores to favorite firms. Two firm names have been there, my lords, List Lucknow and Messrs. Purva Graphics and Office Printers, in respect with file numbers. So in connection with OMR question booklets, without following the due procedure, purchase of e-books without there being any requirement and in the absence of basic infrastructure, and further reprinting of degrees by favored firm violating all procedures and norms in spite of degrees have already been printed, are being investigated. This is the scope of investigation. Now, my lords, without wasting time, I realize, my lords, the workload of your lordships are so heavy, and I don't want to unnecessarily prolong this. Kindly come to the, my lords, short, relevant point furnished to my lords.
That you have filed today.
My lords, yes.
This one.
That's a supplementary affidavit, my lords. That is only to bring on record, my lords, that 62 examinations of various degree course in
Yes.
My lords, has your lordship got it all?
Yes.
I will give you another.
No, I've got it. Got it.
Now, my lords, let me briefly take your lordships, if your lordships wishes, so that when I place them, failure on my part to express it properly could be made up by your lordship's understanding. It's 4 pages. Kindly read it, my lords.
The short note that you've given.
My lords, I'll give another copy, my lords, just in
No,
case.
I have. I've just
This
now
is the
kept-
copy, my lords.
I have just now kept it.
No, there are so many papers that one tends to.
Yes.
Milos, this. Milos, we'll give a paginated version of this, Milos, once I have asked, and he has taken care, Milos. He's a very vigilant advocate on record, Milos. He's getting the whole thing paginated. It's an exercise. Few of them have been assigned that job. Now, Milos, your lordships will kindly see this. 3/7/2019, that is the date prior to the appointment of the petitioner as Vice Chancellor, Magad University. The Purchase Committee, Magad University, under the chairmanship of the then Vice Chancellor, Professor Devi Prasad Tiwari, resolved to purchase of 30 lakhs answer booklets through GEM. The answer sheets were procured, keeping in view the requirement. So in the year 2019, sessions were late, not as late when we came to the year 2020, when it was late by 4 years. Requirement of the number of answer sheet was gone into, and a quantity fixed then. And as per the counter affidavit, this is not a scope of investigation. This is not a scope of any fingers being pointed out. And yet the allegation says requirement not assessed. NIT was floated for answer sheet. And finally, one Bindya Enterprises, Kheda, Gujarat, was declared as L1. The whole exercise of answer sheet, nothing, no secrecy is involved in answer sheet. These are plain, either pages having lines or not having lines. There is nothing official about it except the number to identify the roll number who has written it. 15 lakh answer booklets were supplied and the process for payment was initiated and subsequently paid. Plus, will kindly have a note of it. 18/9/2019 is still 8-9 days before I joined. It is relevant to state here, Professor Devi Prasad Tiwari, the Vice Chancellor of Magad University, Gaya, was also holding the charge of Veer Kunwar Singh University, and during his tenure, he purchased OMR question booklet for Veer Kunwar Singh. Question booklet comes, the allegation of the SUV is, I am trying to misrepresent. I am trying to, what is the word? Obfuscate this honorable court. Prior to my coming, OMR question booklets exercise was undertaken by DP Tiwari, who, my lords, he says, like Caesar's wife, is beyond suspicion. He purchased OMR question booklet for Veer Kunwar Singh University without floating tender through GEM, as the question paper and question booklets are always a confidential matter. If one, I have explained that later also, if one was to take it through GEM, the identity of the question booklet printer would be known. Let's kindly keep it in this context. 62 examination of different degrees, undergraduate, postgraduate, in various affiliated college of Magad University has already been held. Completed result declared, no controversy with regard to either question being leaked. In fact, my lords, such are the vested interest designs that a PIL was filed. A complaint was made to the Chancellor. 2 inquiries with regard to OMR question booklets have already been undertaken by a committee much prior to this FIR, and petitioner has been exonerated. Said nothing wrong except you could have been more transparent. Now kindly come to the next date, 27/9/2021, and nothing so far in the investigation by this, neither about UGC, permitting online mode of examination, nothing, not a word, or about the inquiry undertaken by the Chancellor. 27/9/2021, pursuant to my appointment, I joined as Vice Chancellor, Magad University. On 8/1/2020, the Controller of Examination, who is said to be one of the witnesses against me,
27/19.
That has a typographical error. 27/9/2019. It is typed as 2021, my lords. 8th of January 2020. The Controller of Examination places an order for, my lords, 15 lakh answer sheet, which was the balance pursuant to an agreement reached between Mr. D.P. Tiwari and Vindhya Enterprises. My lords, 15/2/2020, copies were supplied. My lords, on 22nd, my lords, that is official, my lords, Google, internet, everything will specify the date of national lockdown is 22nd of March 2020. Now comes an important annexure which I will ask your lordships to kindly see. Annexure 22, page 25 to 28 of the supplementary affidavit filed by the petitioner. This is UGC guidelines, my lords, published by Press Bureau of India in presence of the minister. My lords, this is a short supplementary, my lords, not the main supplementary rejoinder. Such is the vigilantness of the vigilance.
The affidavit dated 12/5/2022.
My lords, I shall check that. Affidavit dated. My lords, this 12/5.
Yes.
Lords, kindly turn to Annexure 22 at page 25. I will not read the whole of it, my lords, only the relevant part.
Yes.
To complete the sequence. And my lords, before I read that, my lords, kindly have a look at Section 17A of the Prevention of Corruption Act. Why, my lords, that particular provision has been enacted. Criminal protocol. Approval is to be sought for. Approval is to be sought for, and then, my lords, a time frame has been granted by legislature in their wisdom.
Yes.
For a purpose. It's not an idle formality. That since he is the appointing authority, I will grant him this time. Kindly see the second proviso. Provided further that the concerned authority shall convey its decision under this section within a period of 3 months, which may, for reasons to be recorded in writing by such authority, be extended by a further period of 1 month. No, the objective is clear, that the appointing authority, the competent authority under section 17A, will apply his mind to the allegation, see if it is frivolous. Is it going to retard the very process for which 17A has been enacted, that the officers can take fearless, prompt and decisive action in the matter for general good of the work and function that they have to discharge? That's the reason. It's not a reason that a communication to the appointing authority would take more than a day, and a reply pat without consideration of the whole matter will come back the next day. A purpose behind it, and the purpose is salient, will apply his mind, see if it is a complaint, which is precisely what section 17A provides an interdict. Now, my lords, kindly turn to page 25, my lords. I am only pressing that, the second provision, my lords. No words of a statute has to be, my lords, rendered idle, nugatory or obtuse. My lords, very starting line, my lords, kindly see the date. It's 29th of April 2020. My lords, guidelines issued in presence of Union HRD Minister. In view of COVID-19, pandemic and subsequent lockdown, the University Grant Commission constituted an expert committee to deliberate and make recommendation on the issues related to the examinations and the academic calendar to avoid academic loss and take appropriate measure for the future of student. So, my lords, UJC also, not one fine day because pandemic has broken out, my lords, is issuing these guidelines. Expert committee was appointed. The following are main recommendation in the guidelines issued by the UGC today. Lords, kindly come to that. Lords, I'm trying to be brief. I know your lordships want to finish up this matter one way or the other. Whether, my lords, I swim and get ashore or I sink and get drowned, doesn't make a difference. Lords, kindly see. My lords, then they say that the commission on its meeting held on 27th.
You swim and go to shore, that's one.
My
and when you sink, where do you go?
No, sir, go to the floor.
Yes.
My lords, this was accepted. Expert committee report was accepted by the commission in its meeting on 27/4/2020. Without any delay, my lords, on 29th, these guidelines are being issued. The following are the main recommendation in the guidelines issued by the UGC today. My lords, I will, my lords, ask your lordships now kindly to come to the subhead examination on the same page, my lords. Universities may adopt alternative and simplified modes and methods of examination to complete the process in shorter period of time. Universities may adopt efficient and innovative modes of examination by reducing time from 3 hours to 2 hours. Universities may conduct terminal, intermediate, semester year examination in offline stroke online mode as per the ordinance, rules and regulation. Then your lordships will see that, my lords, observing the guidelines of social distancing, and then, my lords, and keeping in view the support system available with them and ensuring fair opportunity to all students. Terminal semester year examination for PG, UG courses program may be conducted by universities as suggested in the academic calendar. The timing of examination may be considered appropriately by the universities, and examination may be conducted keeping in mind the guidelines of social distancing. And then, my lords, there is a note. Kindly come to page 28. Now, the note says, universities may adapt, and implement these guidelines in a transparent manner by making alteration, additions, modification, amendment to deal with particular situation in the best interest of the students, educational institutions, and the entire educational system. Plus, this was the UGC guidelines. Then, my lords, the academic committee, calendar committee met by the next annexure, my lords, annexure 23, which is also the next annexure in the notes that I have suggested. Lords, here your lordships will find 1/6/2020 is the date. It's addressed to the principal secretary.
So you're referring to clause 3 in the light of UGC, resolved to prepare transitory regulations for OMR based exam. Is that what you're trying to say?
My lords, yes. That's exactly, my lords. Kindly see, I'm directed to forward here with the amended academic council.
All right, we have seen that. So therefore you are referring to clause 3, that is the proposal. There shall be OMR based examination.
Next page, there are 3 clauses which I will refer to, 1, 2 and 3, my lords.
Yes.
All are important. A decision was taken, and this is what has been sent to the Chancellor. These are enclosures to this letter dated 1/6/2020. Proposed academic calendar 2020-21 for UG and PG courses in the light of UGC guidelines are proposed.
They clear, Mr. Singh. We have seen
Third.
that. This page 30 you need not labor, I have seen this.
Yes.
Therefore the necessity of buying OMR sheets because of COVID and decision of UGC.
OMR question booklets are required, my lords, because answer sheet, the moment you go in for answer sheet.
OMR based exam with multiple choice type questions.
Absolutely. Therefore, my lords, kindly turn to page 41. Next. My lords, this detail of examination I will come later. My lords, let me tell you, what was proposed then was various examination in various faculty for various examination. An entire list was given. If your lordships will turn to page 41.
But Mr. Singh, let me understand from you, since you have raised this issue at some length. Now, if the OMR based exam with multiple choice question, if there could be any reason for maintaining secrecy,
Absolutely, my lord.
For not going for any purchase through GEM portal, otherwise many such dealers would have come to know.
My lords.
It is not with respect to, I mean, one is not expected to give the questions and then the answers. It is only a dealing between the person who supplies and the university that, look here, if you fall first or the last in the bid, anybody who is the highest bidder or lowest bidder, depending upon the nature of the tender,
yes.
now he shall be under a requirement to maintain that secrecy, because we will be giving questions to you.
My lords, state talking about Bihar, not talking about Bihar, country over I am informed that this question...
No, it has got nothing to do with your case. Now we are only questioning...
No,
just a minute. Now the High Court conducts examination. Many a times we decide, sitting in the administrative side, we decide that it has to be sourced out. We can't conduct the examination because we don't have the wherewithal.
Correct, my lord.
Now once it is sourced out, we we have an option. We source out the questions also, the answers also, and then even the process of inviting objections on the questions and the answers. Now that is one aspect of the matter. If we break it, we say that we will give you the questions, you provide the space where examination online would be taken or OMR question answers will be given, and all the things shall be your headache. Now in that, if we suppose we are doing it all by ourselves. Suppose we are doing it all by ourselves. Now we frame the question. Now even if we try and maintain best of secrecy, would we give the question to at least even two of the bidders? No. We will only deal with them with respect to pricing. Not with respect to question. So therefore, avoiding gem portal, that justification solely would not be very, very satisfactory. Or not asking for anybody. Say, suppose you are taking a decision of choosing a person from Agra. True it is, unless it is proved that there is some extraneous consideration, we can't jump to any conclusion. But only on this argument that you are choosing parties from different places, where is the rationale, who contacted them, how did they come to know that you are in need of such OMR sheets. Now there has to be something on the basis. Now so far as recommendation is concerned, this is only to cut short the matter so that you make a pointed reply. We will ask them questions also. Don't think that you are the only target. The target would be there also. Have the question. Now the other question is that you have talked about requirement under section 17A. This is not with respect to bail. This is with respect to 17A. Now any recommendation made or decision taken, and you know the background, how did it all begin? Vineet Narayan was general, the subject, the administrative advisory number 1 was set aside. The Supreme Court, authored by Justice Verma, he says that no, corruption is something which we must tackle. There are 6 virtues. These are not cloistered virtues. Everyone should have. One of the virtues is that nothing should be done which would bring benefit to the person. Now in order to avoid any speculation with respect to that virtue, everything should be written down. Now this was taken from Justice Nolan's report, right? So this was Vineet Narayan, continuing mandamus. Now then comes this Swami's case, where the similar provision was there in CBI, right? Section 6 of the DPS. Similar provision prior to promulgation of the FIR, prior to lodging of the FIR, but it limited such protection only to officers of the rank of Joint Secretary.
That was 6A.
6A. Only to the rank of Joint Secretary. But while deciding that matter, the issue with respect to the requirement of seeking approval was also questioned and answered. Now this classification under 14 was hit, that's one thing, but that was also answered. And then the ordinance came, which was also set aside. Between the ordinance and the promulgation of this and the other act, there was no requirement. Now in the meantime, with the administrative committee's recommendation, it was decided, because we had the opportunity of going through all these arguments in some other cases as well. Now it was decided that Lokpal, Lokayukt bill should be modified accordingly. But then it came to light that many states do not have a Lokpal or Lokayukt, and therefore that would not be relevant. And then comes 17A in 2018. The purpose was this had a link with respect to a person in CBI who was being coerced not to investigate, or the CBI inertia, right?
Correct.
So therefore the requirement of recommendation, so that any recommendation made would not bring a person within the ambit of investigating tentacles during his service or post his service. Now, what is this recommendation? What difference would it make? I mean, what is the difference? What is the dividing line between a recommendation and a decision taken straight away? Otherwise the use of the word would have been any act done.
Correct.
And then what is the use of the additional word purported to be? Action taken. Action purported towards the official capacity. Why this? No, don't we get back to Khwaja Nazir? Don't we get back to Mata Jog Dubey? Don't we get back to Horil?
Possibly, or purported to be done is missing from 17A. Let me cross-check that. That purported word is gone.
Is not there.
Not
the
there.
offence was alleged.
Let me say,
recommendation made or decision taken?
Decision taken. So, all that, this 17A, which restricts its application by the use of these words, they are the heart and soul of 17A.
That's right. So, have you taken a decision?
Yes, my lord.
Just a minute. Have you made a recommendation that in this time of urgency, we will avoid gem portal?
My lord,
Where is that recommendation?
My lord, let me also say, my lord, that.
No, this is only with respect to 17A. Don't misunderstand my question. I'm not.
I understand, my lord. Gem. What are the dangers once you resort to that particular mode?
Yeah, we have followed the logic. We have followed the logic. The justification. We have followed the justification. Tell me, where is the recommendation?
It will be done that also limited quotations were called for. That's also there from various companies. And the rates were also done. That is good enough that a confidential quotation will be called from reputed firms. That's also there. That's there in the note.
All right. So you take a decision that you shall decide it under secrecy, under cloak of secrecy. So we would like to hear from you, where is that recommendation? Action taken, we have understood. You have taken the action.
Decision taken, OMR question booklets.
The recommendation in this case would be for you to have complete protection under section 17A, as I understand now, subject to how you do the interplay. The recommendation is that, look here, this is the requirement. Now, in view of the UGC regulation and the pandemic and the requirement of maintaining academic standard and timely examination, we do away, the university does away with this. This is the recommendation.
Yes, and a decision.
This is the recommendation.
And a decision followed by an action.
So, action taken pursuant to a recommendation, you are protected.
A decision.
You are protected.
Two milords have a very limited in the sense.
Why I have asked you for this exercise? Because you have labored, I see you have labored much, and it shall be of great benefit to the court. Look here. Now I'm asking something different, Mister. Don't distract him. The instructing counsel. Instructing counsel should not distract. I mean, he's answering my question. He has understood the question. Now you would have read in some of these judgments of yesteryears, pre-1976, which includes even Horil, that Privy Council judgment. There he explained what is the meaning of the word in exercise of the powers vested. An action taken in exercise, this was in context of 197 or 280 of the Government of India Act, which had some semblance with 197. There they made a distinction which was very, very rudimentary, because it was those days, 1936. Today we are in a different time. The timeline is absolutely different. Now that was the time when an example was given in Horil that a doctor is under an obligation to treat a patient. But while treating a patient, he picks his pocket. So this is the example, a very rudimentary, just a minute. This is a very, very rudimentary example which was given to make a distinction between what would not be an official work to have the protection of 197. So this answer was given that a doctor would be perfectly within his rights to treat a person, let that person die because of wrong medication. But while trying to administer medicine to him, he picks his pocket. This is not part of the official duty.
I have seen illustrations like this.
Likewise, there is another illustration that you you have the authority to take a decision, and before that you obtain some privilege from the person.
I'm forgetting that. I will lay my finger on it.
So therefore,
in the judgment before us.
Just a minute. What I am telling you is this: these examples may not be relevant today, because much discussion has gone into, and many a times laws have been changed. The efficacy of the law, when once questioned, it has been modified. Now there has to be some reason to say that there has to be some difference between an act which is not relatable to your official act. Now how would that be? Suppose this kind of explanation does not suit us today, that you're supposed to maintain law and order, you're not supposed to kill somebody. Now this distinction is too blunt to be accepted in this kind of circumstances. Therefore the usage of the word recommendation. Now this was in the context of such officers who had given coal block allotments, and therefore since they have taken a decision pursuant to a policy decision by the government of the day, that this is the way in which the blocks have to be allotted, or license has to be given, or downstream payment like INX social media in Mr. Chidambaram's case. So therefore in such cases whether it would be relatable to the official act.
Yes.
Now
one
there
of
also
the
a
two
distinction
judgments
was made.
possibly on these section 17A, either it is Devinder Kumar or T. Suraj, or T. Suraj.
No, these are all of early times.
I am talking about the present times.
Yes.
The current judgments, possibly they deal with it. What is an act and
Sure,
I'll check that
so
up.
Mr. Singh, facts are clear. Now you finish it tomorrow.
Absolutely, give me half an hour. I'll not, except, could I make a request? I can't even make that. It
Please.
is like asking your lordships to do something. That notes that I have supplied furnishes much further information. If your lordships could just glance through it.
Surely, any document that you give or he gives, without reading I shall not pass any order.
If your lordships could do that
before I
by tomorrow,
yes.
Then
yes.
It would be easier for me
tomorrow
to.
What we do is that we will keep this case fixed from 2:30.
Absolutely.
All such matters which I fix for withdrawal or for early hearing, we will finish it off by 2:30. Now 2:30 to
that will be
just a minute. 2:30 to 3 you argue, maybe 15 past 3, and then we give 45 minutes to it.
3 past 3.
15 past 3.
I thought 3, not 3 minutes. That
15
was worrisome.
So from 2:30, 45 minutes to you. 45 minutes.
I think,
let's conclude.
There is a limit to which I can repeat my submissions. I ought not to.
Mr. Singh, let me tell you, you are not repeating. You have not repeated.
And then, only since we are rising, your lordships are rising for the day. The only thing that I would like your lordship.
If you complete it today, we would sit by around
it can't be complete. The only thought, that I want to set afloat is this. Assume gem has not been indicated.
No, that's all right.
Not been followed.
With respect to bail. Now you are addressing bail. 5 minutes I'll give you. You are addressing the protection of 17A.
Will still lie, even if gem was not followed.
That's your honor. All right.
Therefore, yes. And gem can't be a subject matter for unless and until there is something more. Unless something, allegation that I demanded a bribe from the 2 printer firms on whom order was placed.
Yes.
And there is a complaint made by those printers firm that bribe was ordered, as in the case of Devinder Kumar, as in the case of, the various judgment that I had referred.
So therefore your argument is that it is not ex facie criminal.
Ex facie, therefore the argument. And then, source information, not a thought more. And with regard to a protection conceived by legislature.
Now maintain the timeline, Mr. Singh, that is my only request. Tomorrow we begin at 2:30. Whatever is the matter, we set.
I have kept myself free for this case from any other case where I could have had an engagement.
No, that's
took
true.
that.
You shall be here, but not beyond 3:15. We have to give time to him.
We'll try to do it. Otherwise, my lords,
Otherwise, your arguments would be understood without your making it.
correct.
All right.
There is
Yes.
one matter, one appeal matter. अभी हुजूर के यहाँ 17 नंबर पे था, उसमें हुजूर शोकॉज कर दिया गया था, but the punishment is only for 9 years.
हम बता रहे हैं, हमने बोल कर बोला कि 10 साल का रिक्वायरमेंट है 389 में, मालूम है हमें?
हाँ, वही तो।
मालूम है हमें?
तो हम नहीं कह पाए, लगता है कि
नहीं,
जो
आप
मेरे-
नहीं कह पाए, आपके जूनियर को हमने कहा, उसने आपको नहीं कहा. I said that the requirement under 389 is 10 years and not 9 years. Nonetheless, I am asking for the response. I've said that. ऐसा नहीं है, बिना कानून देखे ऑर्डर नहीं करता हूँ. CRPC उसी समय मंगाया.
कितना टाइम लीजिएगा?
मानिए से जी कैसे कैसे है
सबको बांधिए इस पर.
हाँ ठीक है, इसे इसमें रहता है ना,
आ रहा है.
इसमें रहता है, इसे ये